The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. Well, welcome everyone to Richmond, to the Fourth Circuit Court of Appeals today. We have four interesting cases. And the first one is United States versus Ogle. And Mr. Strobel of Charleston, West Virginia. Good to have you with us, sir.
Thank you, Your Honor.
Right ahead.
Thank you. May it please the court. My name is Paul Strobel, and I represent the appellant in this matter, Brian Ogle. This case deals with the issue of whether the district court erred in applying sentencing enhancement pursuant to the Armed Career Criminal Act at Mr. Ogle's sentencing. Today, I will lay out why the district court erred in applying a sentencing enhancement pursuant to the Armed Career Criminal Act by showing that the Tennessee aggravated assault statute is not a violent felony under the Armed Career Criminal Act, and that the district court erred in its most innocent conduct analysis. For these reasons, the decision of the district court should be reversed, and this case should be remanded for resentencing. In order to qualify for an enhancement under the Armed Career Criminal Act, a defendant must have at least 3 prior convictions for either a violent felony, a serious drug offense, or both. And those 3 convictions must have been committed on separate occasions. The present case focuses on whether Mr. Ogle's prior conviction of Tennessee aggravated assault constitutes a violent felony under the Armed Career Criminal Act. Aggravated assault is not an enumerated felony, or is not an enumerated offense under the Armed Career Criminal Act, and therefore can only qualify as a violent felony if it satisfies the requirements of the elements or force clause.
So let me ask you, we all in agreement modified categorical approach applies here?
Yes, Your Honor.
And so you look at this statute, and maybe I'm looking at it oversimplistically, but that particular offense, the felony, the Tennessee aggravated assault, in this particular one involved the use or display of a deadly weapon. And so when you're looking at a modified categorical approach, you're looking at that particular section there, section A, which is that knowingly commits an assault involved with the use or display of a deadly weapon. Case law is pretty solid on that one, isn't it? Against you, don't you think?
Well, to address that, I would say we have to look at the entirety of the statute. There are 3 elements that make up aggravated assault in Tennessee. The first is mens rea, which is divisible. And so for this case, we know what we're looking at. It's going to be knowingly, because that's what was pled in the indictment. The second is simple assault, which is just the simple assault definition under Tennessee statute. And third, as you pointed out, it can be any of the enumerated offenses under Roman numerals 1 through 4. Again, that's divisible. And so we know that we're dealing with involve the use or display of a deadly weapon. But the question that is presented in front of the court here today is whether someone can knowingly use or display a deadly weapon and commit assault that under the simple assault statute does not meet the requirements of the force clause. Looking at the simple assault statute, there are 3 different means or ways that that statute can be fulfilled. Our position is that the most innocent conduct under that statute is, is intentionally or knowingly cause physical contact with another, and a reasonable person would regard that contact as extremely offensive or provocative. So what we're saying here is the court must use the most innocent conduct analysis to look at that element in conjunction with the other two elements that I already laid out and determine whether or not that meets the definition of a crime of violence under the force clause.
So it's something like displaying a deadly weapon in the course of knowingly causing extremely offensive physical contact. Can I say that again? We'll put all the elements together.
Yes.
Displaying a deadly weapon in the course of knowingly causing an extremely offensive physical contact. Is that fair?
Yes, that is fair.
And Judge Wynn has said the displaying a deadly weapon part under the case law is pretty bad for you.
I would agree that it certainly isn't helpful for our case. However, I do think there's a distinction to be made when you say, can someone display or use a deadly weapon, and the minimum force required, it does not have to constitute a violent felony under the force clause. Again, so if we take a look at what the definition of violent force is in the Fourth Circuit, it's force that must be capable of causing physical pain or injury to another person. The Fourth Circuit has stated that physical force under the Armed Career Criminal Act's force clause must be both violent and physical and violent. And de minimis physical force, such as mere offensive touching, is insufficient to trigger the Armed Career Criminal Act's force clause because it is not violent. So what we posit in this case is we have an incident where two vehicles end up running into each other. In this case, the only deadly weapon that is used or displayed is a vehicle. The next thing we have to look at.
He intentionally used the vehicle.
He did. There's no dispute
as a
about
weapon.
There's no dispute about the mens rea or the Roman numeral, which applies.
So you admit that recklessly is not a part of this?
Unfortunately, it is not. But yes, based on the indictment in this case and what he pled to, it does make clear that it was intentional. So we do know it was intentional, and he used or displayed a deadly weapon. But again, the only
intentional and knowingly,
or either or. Yes.
both.
Yes. Again,
And recklessly is not a part of it.
under my reading of this statute and how it is divisible, again, my understanding is the first element is divisible, and so the court can look at a limited set of documents, Shepard documents, to determine which version of this crime that Mr. Ogle was convicted of. And again,
But the mens rea element was knowingly and intentional.
yes, Your Honor. And again, our fight here today really isn't about the first or third elements. Again, those are divisible, and we can't change those. What we're looking at is the second element, which all falls under just the simple assault statute of Tennessee. And again, our position is that extremely offensive or provocative conduct does not meet the definition of violent force that the Fourth Circuit has asserted again and again under the Armed Career Criminal Act. To continue on about what happened here is we had two vehicles that did collide. Again, the vehicle is the deadly weapon in this case. Mr. Ogle did it intentionally. However, what we have is the individual in the other vehicle was not injured. He sustained no injuries. So what our argument is that you can be involved in a wreck or an accident, and that physical force is certainly extremely offensive or provocative. I don't think anyone would say if you get into a wreck, that's not at least offensive conduct. But does that offensive conduct rise to the level of violent force under the force clause under the Armed Career Criminal Act?
So your problem is that bumping someone with a ton vehicle in an extremely offensive or provocative manner there's a lot of authorities say that's sufficient to be violent force. And so when you look at the overwhelming authority on this, it seems to point that this deadly weapon element in an intentional conduct situation creates this violent felony. Do you have any cases that go the other way?
I would disagree that there's a multitude of cases that point to hitting someone with your vehicle automatically constitutes as violent force under the Armed Career Criminal Act. And again, under this statute, this court has said, and other courts have said, we don't want a perfect idea or simulation of what could happen in a case. So we have to draw from relevant case law.
What about the Ninth and the Sixth Circuit cases from those cases? Are they persuasive for us? The Red Sullivan case and Holland case? Certainly.
I would argue that both those cases are not persuasive here. The Perez Sullivan case is distinguishable because the Ninth Circuit held that they have previous case law that says even the least touching with a deadly weapon, when there's a deadly weapon involved, constitutes a violent crime or a violent felony. I don't think the Fourth Circuit has any similar case law where it says if you brandish or use a violent weapon, even with the least amount of force possible, that automatically constitutes as a violent felony. And that's what the question here today is there a crime where you can use or display a deadly weapon and use a minimal amount of force that does not meet the force clause of the Armed Career Criminal Act? And again, I think our best and really our only example is this case here today. If you take a look at what happened in Mr. Ogle's case, again, you have it's just two vehicles that hit each other. There's no injury. There's no physical force. There's no violent force that was involved. And so for those reasons, we don't believe it rises to that level. To get back to your question, I also believe the Sixth Circuit analysis is incorrect. In the Braden case, the court there didn't even do the most innocent conduct analysis, and they went through the specific violations that the defendant had, which is not how this approach is supposed to be done. And then in Hallam, the court posits they do the correct analysis, and I would encourage this court to follow that analysis, but where they lose it is they say, there's no perfect scenario where this exists. And our point here today is, well, we found one. And the reason it's so hard to prove these cases is because if you look at what we have to draw from as defense counsel, almost every case now is done away with by a plea deal. Very few cases go to trial. Very few cases are tried. So the records that we have to go through are minimal and often not even kept. So what we have is a defendant who, at the lower court, pled to what is aggravated assault, which I think...
Did you represent this fellow in the district court?
I did, Your Honor.
So you've been in this case all along. Why'd you give up the categorical approach so quick?
Your Honor, when looking at the categorical approach, the first thing we look at is...
Well, I know, why'd you give it up so quick? The Tennessee Supreme Court talks about this mens rea as being an element,
Correct.
one of three elements.
Correct, Your Honor.
Right? That sounds like it's singular. Right? And you can commit that first element, mens rea element, under the Tennessee statute recklessly. And you gave that up.
That is correct, Your Honor. And I did raise that at the lower level because my first reading of this statute is that it's inherently contradictory. Because one, it says you have to intentionally or knowingly do something. But at the same time, one of the elements that you cannot get rid of is that it can also be done recklessly. So I certainly understand the court's point and think it makes a valid point.
And very strong if you could have gone there, but I understand it to some degree. You got three different punishments here under this statute for these different mens rea. So it's very difficult to categorize it just as, one of a better term, categorical.
I agree. And I think the other thing we have to look at is the case of state of Tennessee versus Hammonds. And I think that's an important case.
Hammonds is what I was talking about.
Yeah, and I think
They
that's
talk about mens rea in the singular.
absolutely. And I think that's an
That's why,
important.
and we're supposed to give deference to these state courts.
They are, and what they say is,
And you'd have a better argument by trying to say it's a categorical approach. But then you'd have to get around the question of punishment, as Judge Wynn said.
right, and that's why I think that approach failed, and I thought our best approach, and the approach that actually can be successful, is to look again at that second element. We're still looking at the simple assault definition in Tennessee, and
Well, I know you're talking about the second element, and I'm talking about the first element.
yes.
We're on different channels.
No, I certainly understand what the court is saying, and I'm saying if the court goes down that route, I agree.
And you got some cases against you. There's a well-written case in the Ninth Circuit and one in the Sixth Circuit that are dead set against you. They say that the mens rea element characterization by Hammonds doesn't mean what it says. But these are courts of appeals saying that the Supreme Court of Tennessee doesn't know what it's talking about. But anyway, if you want to give it up, you can give it up.
Well, certainly, I think if the court thinks that there's validity there, then we would certainly assert and agree with the court that there is a serious issue in saying that it can at one time be intentional, at the same time be reckless. I mean, that doesn't make sense. And as the United States Supreme Court just pointed out in Borden, if something is reckless,
They were dealing with this very same statute.
They were.
They were talking about the difference between those. We'll talk about the first element: knowingly, intentionally, or recklessly.
Correct.
And so recklessly can't be a crime of violence.
And they held that if it is reckless, it cannot be held as a crime of violence. And so again, if this court is persuaded by that argument, then certainly this would not count as a violent felony under the Armed Career Criminal Act, because the Supreme Court of the United States has held that if the mens rea is reckless, it does not constitute as a crime of violence. But again, I still think our argument is able to prevail on just that minimum conduct. It's either extremely offensive or provocative, and that is not enough to meet violent force under the Armed Career Criminal Act. I see my time has expired. Thank you.
You've saved some time, Mr. Strobel, for a rebuttal. Mr. Wolf, you going to tell us about the government's position?
Thank you, Your Honor. May it please the court. My name is Jeremy Wolf. I'm an assistant United States attorney for the Southern District of West Virginia. I'm here on behalf of the United States in this case, arguing that the statute in question is a divisible statute, that the minimum conduct punishable under the elements of the defendant's conviction satisfy the force clause as a threatened use of violent physical force.
No reading of it would render it a categorical approach we should make in light of the Tennessee Supreme Court's treatment of mens rea?
Your Honor, the Hammonds decision is an important one in this case because it talks about the statute in question. But the aggravated assault statute in Tennessee sets forth multiple distinct crimes based on the alternative element of mens rea. The Borden opinion deals with the reckless variant of aggravated assault. And the Borden opinion...
You think mens rea then is a plural term as used by the Supreme Court of Tennessee?
Yes, Your Honor. And I think...
But they use it in the singular. They put a number 1 in front of it. And then they go to the second element, they put a number 2. They say 1 mens rea, 2 words, Latin words. Then they go to number 2. So you say, even though they say mens rea, that means multiple.
Yes, Your Honor. And there are multiple different mens rea that a prosecutor can choose from under the statute.
Mm-hmm.
The statute at the time of Borden's conviction and the statute at the time of this defendant's conviction are a little different. They're renumbered, relettered, but they each set forth a separate crime for reckless aggravated assault, a separate crime for knowing or intentional aggravated assault. And the reason I say that, reckless aggravated assault carries a different penalty from knowing an intentional aggravated assault. And we know from Supreme Court case law that if there's an alternative element that alters the potential penalties, then it has to be alleged and it has to be found by a jury beyond a reasonable doubt. The Supreme Court in Borden recognized this. One of the footnotes, footnote 8, the Supreme Court recognized that there's a different penalty for reckless aggravated assault as compared to knowing or intentional aggravated assault. I think they call it purposeful aggravated assault, but different penalties. And so that has to be alleged and it has to be proven. Mr. Strobel discussed the instant case being an example of his formulation of most innocent conduct. I would submit that it's not. The charging document in Mr. Ogle's prior aggravated assault conviction actually does allege the variant of simple assault involved in the conviction, and that being that he caused the deputy to reasonably fear imminent bodily injury. And so it wasn't a extremely offensive or provocative physical contact. The minimum conduct analysis, when it comes to this case, is complicated a bit by State versus Tate, a decision that came down from Tennessee's Intermediate Appellate Court. And it appears to be the first and most recent word on this issue from either the Intermediate Appellate Court or the Supreme Court of Tennessee. And it talks about what is aggravated assault in the context of a motor vehicle serving as a deadly weapon. And so the Tate decision talks about not only what you have to allege, it talks about what you have to prove to get an aggravated assault conviction when the motor vehicle is used as the deadly weapon. And the court in Tate says that there are only two ways to prove when a defendant in Tennessee knowingly or intentionally uses a motor vehicle as a deadly weapon, only two ways to prove the underlying assault. That being causing bodily injury or an act that causes another to reasonably fear imminent bodily injury. And so what Tate does, it takes Mr. Strobel's minimum conduct theory off the table, because that's a general statement from Tennessee's Intermediate Appellate Court. It's not been overturned by the Supreme Court. The case was cited in Hammonds, but for a different proposition, and it was cited favorably by the Supreme Court in Hammonds on a different point. And so really what Tate does, it creates two different versions of what the minimum conduct could be. If there's a motor vehicle involved, then the minimum conduct is knowingly committing an assault by an act that puts another in fear of, reasonably in fear of imminent bodily injury involving the use of motor vehicle, or knowingly causing extremely offensive or provocative contact, physical contact, involving the display of a deadly weapon other than a motor vehicle.
Why does the type of deadly weapon used matter for our analysis? Even if we're in a modified categorical approach, it's still categorical. You're not suggesting that this statute is divisible by the weapon used, are you?
I am not, Your Honor.
Okay.
I'm only suggesting the modified categorical approach only goes so far as to tell us that the mens rea is knowingly, and that the aggravating element, the third element or the aggravating factor, whatever you want to call it, is the use or display of a deadly weapon. I'm not suggesting that it goes farther than that and allows us to look at the charging documents and judgment documents to see exactly what weapon is used. But I bring up the Tate case because it directly meets what Mr. Strobel was saying is the minimum conduct punished under the statute.
It's a simple statement that a common law assault accompanied by the use of a deadly weapon is in and of itself it is a violent felony.
I believe that's true, Your Honor. And the example given by the
example, that's all it is. That's all it is, a common law assault, deadly weapon, violent felony. What else do you need?
I agree, Your Honor. If you commit a common law assault,
the underlying reason that's why that is so, the cases are pretty much clearly there. We've got the Bryan case even here to deal with it, but it's a difficult situation once you get those two things together. And as Judge Russian said, the character of the weapon shouldn't matter.
it shouldn't, Your Honor. It's a deadly weapon. Deadly weapon under Tennessee law, I defined it in my brief. but essentially it has to be designed, made, adapted, or in the manner of its use or intended use, capable of inflicting serious bodily injury or death.
You're saying you can commit that recklessly as well as knowingly?
I'm sorry, Your Honor.
And you can commit that assault recklessly as well as knowingly and intentionally, and it's a crime of violence.
No, it has to be committed with a mens rea greater than recklessness. And we know that it was.
The mens rea has to be intentional and knowingly.
Correct, Your Honor.
It can't be reckless.
That's right. Yes, Your Honor.
And the statute says in B that you can recklessly commit an assault involving the use or display of a deadly weapon.
A conviction.
So that wouldn't that part of the statute wouldn't be a crime of violence.
And Your Honor, I agree. If the Tennessee aggravated assault,
That is true, isn't it? What Judge King just said.
it is, Your Honor.
In other words, he's saying if you're looking at recklessness and the weapon, that doesn't do it. It has to be, your statement has to be intentional and knowing to get there.
Correct, Your Honor. And I agree that if this statute,
So why wouldn't the minimal conduct have to involve reckless conduct?
the modified categorical approach shows us that the elements of the defendant's conviction involve at least a knowingly, that the assault was committed knowing.
Well, how do you get to the modified categorical approach if the statute on the face of it talks about recklessness?
It does, Your Honor. And the statute.
And the conviction order here, what it says, aggravated assault.
And the statute in question sets.
And you can
forth,
commit aggravated assault under the Tennessee statute recklessly. Right there on the statute. And
the statute sets forth.
the conviction order says says aggravated assault.
And the information that he pled to, the elements that he admitted to from the information show that.
Well, you got to get to the modified categorical approach to look at all that.
That's correct, Your Honor.
That's
and
right.
the statute in question, the aggravated assault statute, sets forth more than one crime. And that's the issue here. Reckless aggravated assault on one hand, and the Supreme Court and Borden actually refers to it as reckless aggravated
That's just a
assault.
simple answer. Simple answer is one is a Class C felony, the other is a Class D felony, different penalties. And you've got Apprende and Mathis in the discussion.
Correct, Your Honor. And the footnote in Borden, footnote 8, recognizes the difference in penalties. And actually, the Borden opinion also recognizes that, you know,
But to get to where you're going, then you got to get to the penalties.
correct, Your Honor.
You got to get to the modified categorical approach, and then you got to look to the penalties. Is that right?
Agreed. And
That's
yeah.
the logic of getting to it.
So you see that the statute sets forth multiple offenses, one of which doesn't qualify, reckless aggravated assault, one of which would, knowing or intentional aggravated assault. And so you need to go to the modified categorical approach to figure out what elements were.
Once you get to the modified categorical approach, your position's correct. It's fixed, right?
Correct.
The only way that Ogle can prevail here is if he can some way keep this with the categorical approach.
I believe that's correct.
And establish that the mens rea is singular, right? That these alternative terms, intentionally, knowingly, and reckless, are means rather than elements. That's what the cases talk about. Are they elements where they have the ors in them, or are they means, M-E-A-N-S? And the only way that Ogle can come out ahead is if he could convince us that the law supports the proposition that these are means.
Agreed, Your Honor. And I think Borden, at that point, if the statute's indivisible, at that point, we're within the ambit of Borden. But since we have a divisible statute, we don't.
Those two had the same punishment. Would we have a different conversation?
I think it'd be a harder conversation. The statutes.
It's an easy it's a different conversation altogether, not just harder. If both of those had the same punishment, classified maybe as the same offenses, I don't know if the classification makes a difference. It seems quite clear to me, following Judge King's statements, which I think are correct on that line, we'd be talking categorical, wouldn't we?
But Your Honor, I think at that point, we'd have to dig in a little bit deeper as to how the offense is generally pled and how the jury instructions work in Tennessee. I don't think we really need to get there because the penalties are clearly different. And so on the surface, different penalties, disjunctively phrased statute, it's divisible.
Yeah, I was just asking hypothetical. That's not the case.
And I agree, Your Honor. It would be a much longer conversation if it had the same penalties. But if there are no further questions, I would simply ask the court to affirm the district court's decision that the elements of the defendant's aggravated assault conviction, as determined, properly determined by the modified categorical approach, satisfy the force clause of the Armed Career Criminal Act, and thus properly classified as a violent felony, and would ask the court to affirm the district court's sentence.
Thank you, Mr. Wolf. Mr. Strobel?
Thank you, Your Honor. To address a number of things that the government pointed out, I'd quickly like to address the Tate decision. It's my position that Tate does not limit or change the Tennessee aggravated assault statute. That was a decision by the Criminal Court of Appeals in Tennessee. And again, I would rely on the case of Tennessee, the state of Tennessee versus Hammonds, because that case makes it clear that anytime aggravated assault is pled, the government can meet the second element by any of the three means listed under Tennessee simple assault. So I don't think that case can be held. I don't think Tate can be held to limit, and I don't think it's appropriate to state that because a motor vehicle is involved, this case should be looked at differently than any other case under Tennessee aggravated assault. To follow up on a point you were making, Judge King, again, that's not the route that we were taking, but if this court does read Hammonds as the mens rea is singular and the statute is not divisible, then this court would have the authority to use the categorical approach instead of the modified categorical approach.
Except Hammond didn't even talk about reckless assault in any way. It was dealing with a statutory subsection for intentional and knowing assault.
And again, that's if this court finds that Hammonds reads that, it would have authority to do that. I'm not here to argue that Hammonds states that, because I think the more clear argument, again.
You're not here to argue what?
I apologize. My main argument is that under Hammonds, if you look at the elements or the means that make up simple assault, if you look at the least violent force that can qualify.
Well, Hammond dealt with aggravated assault. It assigned those three elements that said for aggravated assault.
Correct.
Number one, mens rea.
Correct.
Then it went to number two.
Correct. And what I was trying to point out, again, if it holds that mens rea is not divisible, it's not a divisible element, then this court would have the authority to find.
Well, we would have the authority, but we got to figure out what the law is. You're supposed to be here helping us and making an argument as to what the right position is.
Yes, Your Honor. And I understand that.
You sound like you want us to be your law clerk or something.
Of course not. And again, that's why I keep coming back to, if you look at the second element, I think that's the easiest way to prevail in this case, because what you have is, does extremely offensive or provocative conduct rise to the level of violent force under the Armed Career Criminal Act? And I posit that it does not. Again, and the government cited a similar scenario in its brief. Let's say you're sitting in a crowded parking lot.
Well, counsel, I mean, of course it doesn't, but that's why assault is not doesn't qualify as a violent felony. The question here is, does the addition of a deadly weapon take it into that category? We have cases where, robbery was not a violent felony, but the addition of a deadly weapon made it a violent felony. So you need to tell us why the addition of the deadly weapon doesn't change the category.
Certainly. And I guess what I'm trying to show here is that there are scenarios where you can have a deadly weapon like a motor vehicle, and it does not rise to a level of a violent crime, because you can have let's say it's a fender bender. You're sitting in a crowded parking lot, someone cuts you off or takes your spot. You get angry and you decide to strike them with your vehicle. They don't have to fear imminent bodily harm because they may not even see it coming. They don't have to receive any bodily injury. It might just be a fender bender. And the only thing that happens is they're offended, they're extremely offended or provoked. Again, that would qualify under Tennessee aggravated assault as Tennessee aggravated assault, and that someone could be convicted under that set of circumstances. Again, I'm saying here today, if that's the case, that does not rise to a violent felony under the Armed Career Criminal Act as defined by the United States Supreme Court or the Fourth Circuit. But if you all don't have any further questions, I see I'm running out of time again. I would just ask that the court find that the district court erred in applying the enhanced sentence under the Armed Career Criminal Act, to reverse that sentence and to remand it for resentencing. Thank you.
Thank you, Mr. Strobel. We appreciate both arguments, and your appeal will be taken under advisement. With that, you're free to go, and we'll call the next case, Madam Clerk. And particularly Ms. Davidson-Welling,
Yes, Your Honor.
and you're representing the appellants here.
Yes, I am.
Pleased to have you here. Look forward to your argument.
Thank you, Your
Honor.
Honor. May it please the courts of deceased PPG retirees. As you know, this case arises from PPG's decision to terminate the retiree life insurance coverage of retirees and to transfer them to a third-party axial in connection with a sale of operations.
Before you go there, let's make sure we have those facts right. You said PPG terminated. Did they?
Yes, they did. PPG terminated the coverage of the retirees under the PPG life insurance plan, as the plan administrator testified, and that's at JA 1359 to 1360.
What year did they do that?
That termination occurred in, I believe, in early 2013.
When did they transfer that particular interest to the third party this year?
So after the sale was completed, they transferred the liabilities they transferred the retirees after terminating their PPG life insurance coverage. They transferred the retirees to Axial Corporation, to a benefit plan there.
So Axial Corporation had it after the transfer. They continued to make payments for it, or who made the payments on this life insurance and all this stuff?
Well, so Axial set up its own life insurance benefit plans, right? And Axial was in charge of those benefit plans, which it kept for a couple of years. The PPG life insurance plan continued during that time to provide PPG life insurance to other PPG retirees who had not been removed because of the sale of operations.
I just want to be clear on it, because maybe I just didn't read it quite that way. You're saying there are two life insurance plans here?
Yes, Your Honor.
One Axial and the other one, and that one wasn't, it's not the same one that was continued from PPG. PPG kept this one going with the other sections that it had.
That is correct, Your Honor. There was the initial PPG life insurance plan, which continues today. And then Axial, after they were transferred over, set up a separate Axial benefit plan, which was in existence for a couple of years and then no longer.
These employees were dropped out of it.
Correct.
Okay.
So
I just want to make sure I understand it. PPG, you're saying they didn't terminate the coverage, continued the coverage under their plan for 2 years for the same thing that they had from PPG.
So PPG terminated the life insurance coverage under the PPG life insurance policy, right? The retirees coverage under the PPG plan terminated. That happened. And then there was a separate later termination of benefits that was conducted by Axial. In effect, there were two terminations here. And the one that is at issue is the termination by PPG of the retirees from its benefit plans.
This is a welfare benefit.
In large part, with the exception of the surviving spouse income benefit. But yes, and we ask that be reversed on counts 1, 7, and 8 because
You're appealing 3 counts.
Correct.
1, 7, and 8.
Yes, we are, and that's because PPG's actions violated the terms of the life insurance plan.
And you're focusing, as I see it, on a 15-year span from 1969 to 1984.
Yeah, with respect to vesting, right? We have. There's sort of 2 separate theories of liability on count 1. One is a violation of plan terms, but
An express vesting language that was in the plan in those years.
So, prior to let me see if I can answer that. Prior to 1969, there was a reservation of rights clause in the PPG plan. Right. And then in 1969, PPG decided to remove that language from the plan.
Right. So that's language that was not in the plan. But what language that was in the plan showed a clear and express intent to vest?
Well, we contend 2 things. One, there was language, the SIB benefit is referred to as a guaranteed lifetime income, which is contractual vesting like CUP. Demonstrates intent not to vest benefits. Logically, the converse is also true.
So I thought in your brief you said there was no clear and express language that showed vesting, and that's why you have to rely on the argument you're making now, right, which is this sort of inverse, right? Because there wasn't a reservation of rights during those years, therefore we can infer vesting.
Well, if I could clarify that a little bit, I think that the act of physically giving up and amending the plan to remove the reservation of rights was a clear manifestation of intent to vest benefits. That act and that inference is confirmed by the Employee Benefit Committee minutes, which say, these are the official minutes of the committee in charge with, overseeing PPG's welfare plan.
But you acknowledge that our precedent says there should be clear and express language.
I'm trying to think if the exact language is that there needs to be a clear manifestation. Now, keep in mind, there aren't any cases that this court has considered anything like this. This fact pattern is really, really unusual. There might never be another one of these. And so the question of whether this is clear, satisfies any question of, clear manifestation of intent, it's different than what was conceived of before, but nobody ever considered this, right? This might be a different way of.
What makes this so different? Is it because it's dealing with surviving spouse here, as what you're talking about, and also probably because generally when a pension, it's not a pension, I know it's a welfare, but when it's vested, the individual who gets vested it, there's no contingency on it. Here, you can have a surviving spouse, but you get divorced or separated or the spouse goes away, you don't have it. And so you can have a vested right, but it can become unvested by the employee who's working there, which is kind of interesting to me. Isn't that interesting that you're saying it's vested, but it's vested that the rights of a surviving spouse to get its lifetime insurance benefits, that's contingent, of course, upon death, which I guess would be a vested interest, vesting of it. It's going to depend on this employee continuing to be married to that spouse. So if he or she decides, I'm going to separate, I can get rid of your vested interest. Is that right?
So there's a lot there. Let me see if
it's pretty simple. It's pretty simple. It's only dealing with this surviving spouse vested thing that I think is interesting. You said it's different, and I'm saying I agree. That sounds very different to me. For characterizing it as a vested interest, because it's dealing with a third party. It's not the employee, the vested interest. And you're saying, but the employee gets this vested interest for his wife because it's only spouse under the statute. If you separate or divorce that spouse, they don't get it.
Right. The benefit is exactly that. That's what you get. However, it is vested in the sense that it is unalterable by the employer after it's granted, right? And that, benefits, once they are vested, cannot be unvested.
And as of 1969, they took a R&R, or whatever it's called, reservation of rights provision out that would have allowed them to modify or terminate the plan. And in 1884, they put it back in. And then they didn't have any records to disclose as to what that was all about, right. Except they later said they did it because it caused doubt in the minds of the retirees and the sense of security that retirees look for. So boys being absent. And they said the legal ability to enforce the reservation of rights was in doubt.
Your Honor,
they recognized the legal problems with it.
Right. Your Honor is correct. Those employee
but they didn't come up with the discovery until after the summary judgment.
No, they did
motions have been filed and submitted to the court.
That is correct, Your Honor.
So right. That's the big distinction there, is that reservation rights clause being there and then taken away and put back, and then later on not being able to discover.
Well, the reservation of rights clause that was added back into the plan in 1984 could not be effective as to the rights of vested rights, right? It could cut off rights for future hires. But as this court recognized in the Wheeler case, once an employer grants vested benefits, it can't take them away by amendment.
But now, is vesting a legal question or a factual question?
I think it is a legal question based on undisputed facts.
A legal question for then the district court said it was vested.
The district court didn't. The district court dismissed retirees' claims.
The district court didn't actually address this particular point.
That's right. The record did not.
Why wouldn't the vesting be a factual issue?
Well, I think vesting in this case. The facts are undisputed in this case, right? So
that it's undisputed. Well, but it's a factual issue. But if it is disputed, you'd be entitled to a jury trial on whether it's vested. They were vested from 1969 to 1984.
If there was a dispute, we would be entitled to a trial. Yes.
On that fact,
On-
at least
on-
that fact. I don't know what else. There might be other facts too, but on the vesting question, I thought you were going to say it was a factual question rather than a legal question.
Well, it's just because the facts are for, I think that the record is undisputed on the facts that are here, but it is true. There's a dispute as to vesting.
And because
for
they didn't
sure.
make discovery on it, you might be entitled to an adverse inference.
Yeah, I mean, I guess that would also be.
I think you'd be arguing that.
So in addition to the vesting question, there's also another argument that we have made, which is really just that PPG didn't follow the terms of its own plan, and it can't defend against that as it's tried by saying, hey, look, there was a reservation of rights in the plan because it didn't use it. At the time of the Axial transaction, and this is separate from the vesting argument, which is a separate basis for liability, but the plan at that time, right? ERISA plans are supposed to give participants notice of their rights and obligations under the plan, right? That's in the statute. The statute requires that participants be told about eligibility rules and events that can lead to the loss of coverage. That's in 29 USC 1022B, right? And here, over 30 years prior to the Axial transaction, that the plan, which was also the SPD's, or the same document in this case, had sections listing events by which you could lose coverage, and it never included a sale of operations, right? And that's evidence that was not an intended basis on which you could lose operations. Now, as we pointed
So it's
out,
transferred down to Georgia, wasn't contemplated anywhere.
correct. It
Let
wasn't.
me ask you this before you run out of your time here. How many retirees were affected by the termination of the benefit?
So there were. It's.
You've got 8 plaintiffs here.
Got 8 plaintiffs.
And you claim it's a class action.
I don't remember the exact number, but it was more than 1,000, probably less than
More than
2.
1,000? How many were working, already working in 1969?
I think, I don't know that I've ever counted it, but I believe based on the records we have, a significant chunk of them would have been working at some point between 1969.
No, but how many were working in 1969? Answer the question I asked.
I do not know the exact number.
How many were hired between 69 and 84?
I do not know the exact number, although.
How many were working in 1984?
Well, all of the retirees and many of the putative class members.
But you don't know.
I don't have the exact numbers. I could determine that and submit a supplemental brief if Your Honor would like. Yes, our position is that vesting, it occurred and it couldn't be taken away later. And, and the EBC minutes really spell out that the reason that amendment to the plan was made was in order to provide security to employees in response to their concerns and make sure that those benefits were unalterable, to reassure them that they wouldn't be taken away later. That's why they did it. That's what those minutes say. Just sort of going back to the SIB, because we haven't really, that benefit is a pension benefit under ERISA's.
SIB means Survivors Insurance Benefits.
Yes, it does, Your Honor.
Yeah, these acronyms bother me.
There are many of them. I'd like to refer to it as SIB if that's okay. But that survivor's benefit in the plan satisfies the definition for a pension benefit, right? By definition.
Can I ask this benefit the retiree could choose 2 different ways, right? A 50% lump sum or a 25% lump sum, and then monthly payments?
Correct.
If the retiree chose to have the 50% lump sum upon death, would it be a welfare benefit?
Yes.
So the same benefit, if the retiree chooses the 50% option, this is a welfare benefit. But if the retiree chooses, no, I want it paid out 25% and the monthly payments, the retiree has turned it into a pension benefit.
So that is the language of the plan, right? You can waive part of your lump sum benefit, which is a welfare benefit, in exchange for a guaranteed lifetime income.
So it's a hybrid kind of thing?
It is a hybrid kind of thing.
But the money is all coming from this life insurance policy. It's not as though if you choose the 25% and monthly payments, they start deducting something from your compensation to pay for those monthly payments,
So,
there's no difference in how it gets paid and how it's funded.
right, I think there was a separate class of premiums for individuals in this category who had
Mhm.
elected the benefit. So yes, there was a difference in how, in the payments.
Are you claiming it's deferred? It then becomes deferred compensation if you choose 25%, but not if you choose 50%?
We had alleged it as both a retirement income and deferral of compensation. So, but it sort of the, you know,
Is there evidence of that? Was it actually compensation that was deferred, or?
correct. And it was also retirement income, which is another basis.
I'm sorry, I'm not asking characterized under the statute. I'm saying, is there evidence that that actually took place? That compensation was withheld to then be paid out in these monthly payments after death?
The deferral of compensation, that part of the statute says that it can be deferral of compensation to retirement or beyond. Here you would have, it would be a deferral beyond.
Great beyond.
Correct.
But so are there facts that show that that's what happened here?
I mean, there are certainly facts that show that the benefits were granted and that, or that the benefits were offered, and that they could make an election that would extend when you would get compensation, right?
Well, you're saying there are facts that show that you could choose 50% or 25%. And you're saying if you choose one, you make it a welfare plan. If you choose the other, you make it a pension plan.
Right.
The same benefit.
The lump sum benefit is the lump sum benefit is a welfare plan benefit, right? The guaranteed income is a pension benefit. So
the lump sum on either option 1 or 2 is a welfare benefit, you're saying? That it's only this payment for the surviving spouse that it becomes a pension benefit?
Correct.
Is that your view of it, or is that the stipulated facts, or is that a legal determination that you're making, or that's been made by somebody?
I do not believe that is a legal.
Is that part of the agreement?
Yeah, well.
Is that part of an agreement that was, or it's manifest in the paperwork here?
Yes, I think it's manifest in the paperwork that you waive part of your sort of normal.
I mean, the characterization as welfare or pension, is that what you're telling us what it is? Is that the gospel? Is that the way is y'all stipulate, the parties stipulate that that's the fact here, that part of it is, it's a hybrid operation and a part of it is a pension and part of it's welfare?
There was no such stipulation.
No such stipulation. So where are you coming up with that? That you giving us your opinion?
That is.
Is that your opinion, a legal opinion that you have come to? Or that's what the record reflects? Or I just don't know where it's coming from.
Yeah, I think that.
Because I read all this stuff and I couldn't figure out what it was. The best I could, and I'm not the expert in it or anything, but it was a mystery to me which one was which, and whether you could have a hybrid. I was surprised you'd say you could do that. Maybe you can.
Yeah.
You all know more about ERISA than I do.
Held as a hybrid. I mean, that is interesting language. And it also opens up the question. What you're saying is, in option 1, you have a complete welfare benefit. Option 2, you didn't get a hybrid. Part of it's welfare, part of it's hybrid. Where does that go? I mean, is an option 3 possible where you could have multiple type things there, and some of them would be welfare and some would be pension? How does that, and it's all come from the same pot, going back to Judge Rush's book.
Yeah, so ERISA sets out these definitions.
And how long does the survivor spouse get this benefit if they opt for that until the spouse deceased, I guess, like Social Security benefits?
Yeah, remainder of life.
So everybody's kind of rolling the dice on how long the checks are going to be paid out on a monthly basis. Could be 6 months or could be 40 years.
Correct, right. And if you don't predecease your spouse, you don't get the benefit at all, even though it's irrevocable, right? Just like a normal, just like a regular pension benefit. I mean, this surviving spouse income benefit in the life insurance plan was virtually identical to the same benefit in the pension plan. The both of them, like I might be out of out of time.
Well, if the surviving spouse was receiving benefits when the SIB, under the SIB, when the life insurance benefits were terminated, were those monthly payments cut off or have they continued?
It is my understanding that those payments have continued, that the group that we're talking about.
So they must have been vested.
Correct.
So they must have been vested.
Yeah. I mean, we believe pensions are non-forfeitable by statute, right? Welfare benefits can become vested contractually, but the ERISA doesn't require that. In this case, with respect to the surviving spouse income benefit, it was both, right? You have this vesting language calling it, guaranteed lifetime income, but you also have, by its nature, a lifetime annuity benefit to a retiring spouse provides retirement income.
Well, under your hybrid theory, only the monthly payments for people who chose that second option would vest, but the 50% and the 25% wouldn't be required to vest because they're welfare plans. They're not pension plans. The only pension plan under your hybrid approach is the monthly payments. And so different legal regimes would cover two parts of the same benefit.
That's correct.
Yeah.
Well, we have extended your time a little bit here, but that's fine. We're trying to understand this thing and we'll be fair to the other side too. You've reserved some rebuttal time.
Thank you.
Mr. Torres?
Yes, Your Honor.
I'm glad to have you here. Look forward to your argument, sir.
Thank you for having us, Your Honor. So may it please the court, I'd like to start with actually the surviving spouse pension question. So I think there's some arguments here that counsel is not accurately describing. The only document that they point to in support of this argument is the welfare plan that provides this benefit. And that has two components, as Your Honor noted. It either pays 50% upon the death of the retiree or it pays 25% with subsequent payments. So there is no hybrid alternative. It talks about a life insurance benefit that can be paid two different ways.
So you disagree with your opponent here? You say there is no hybrid.
There is no hybrid. And the reason there's no hybrid is because we need to go back to the statute and see what Congress told us about how.
Are these pension benefits or welfare benefits?
That's exactly right, Your Honor. And the statute.
Which are they?
And it's a welfare benefit. And the statute.
All of them are welfare benefits?
Yes, they are, Your Honor.
No pension benefit.
There is no pension benefit.
In your view?
In my view, and I think in the statute's view.
Is that a factual question or a legal question?
If you look at, it's a factual question. If you look at the text of the plan and you apply it to the statute, that's how you get to the answer that there is no pension benefit at issue here.
How do we know what the plan was in 1969?
Well, that's not relevant to this, Your Honor. The question is what the plan was at the time the benefits were transferred to Axial under this court's rulings in Pierce and Gable. You look at the benefit plan at issue when the disputed act occurred, which was the transfer of these benefits to Axial in 2013. And we know what the benefit plan said in 2013 because it's in the record of this case. And if you look at that language describing the two forms of payments, and then you go back to ERISA and you look at how it defines pensions and welfare benefits, you will find an answer to this question that's quite simple, not as complicated as counsel would suggest. A pension plan, by definition under the statute, provides retirement income to employees or results in a deferral of income by employees. Conversely, a welfare benefit is established for the purpose of providing for its participants or beneficiaries benefits in the event of death. What we're talking about here is not a payment to an employee because the employee's dead, nor are we talking about a deferral of income by the employee because the payments that the spouse is receiving is coming from a life insurance policy that was unilaterally established by PPG. So neither of these payment schemes that are set forth in the plan document that was in existence in 2013 fall within the clear definition of pensions that Congress established in 1974. All this other arguments about whether they're similar or whether it provides retirement income to a surviving spouse is all beside the point. This is a clear case of applying the statute to a clear and unambiguous payment scheme that's clearly set up in a retiree life insurance plan.
Is that all this argument depended upon us determining, or at least your assumption, that there was no vesting of this prior to 1984? That if in fact there had been vested, that, you know, could later plans then control or revoke previously vested benefits?
Well, they could, Your Honor, because in 1969, none of these putative class members were surviving spouses, so they hadn't yet begun receiving these payments. And none of these retirees now had retired yet. So if you look at this court's decision in Pierce, where there was a benefit plan established in the 70s that provided lifetime benefits and then was subsequently amended to include a reservation of rights clause, this court said there's no vesting because before the challenged action occurred, the employer exercised its prerogative as permitted under ERISA to encumber a welfare benefit plan with a reservation of rights clause, which would defeat any claim that there was a vested benefit in 2013, regardless of what PPG may have said in 1969.
But here I'm sorry.
Just one quick question.
You go
Does
right
it
ahead.
matter if the vesting relates to a welfare benefit as opposed to a pension benefit?
Congress drew a very clear distinction in ERISA that welfare benefits as a base proposition are not vested. It only established vesting requirements for pension plans. This court has recognized in a number of cases, though, that an employer can choose to vest a welfare benefit. However, this court has also repeatedly recognized that the inclusion of a reservation of rights clause in a welfare benefit plan defeats claims of vested benefits, Your Honor. So the fact that you can opt to establish a vested welfare benefit doesn't mean that you're somehow precluded under ERISA from later changing your mind and inserting a reservation of rights clause. That was the whole statutory purpose that Congress set forth, which this court has talked about in numerous ERISA decisions, that they wanted to give employers flexibility, Congress in enacting ERISA, the ability to decide whether and when to provide welfare benefits. And that's why they drew this distinction between welfare benefits that aren't vested by statute and pension benefits that are. And what we're dealing with here is undisputedly a life insurance plan, and it undisputedly provides payments to a beneficiary upon the death of the retiree. That does not fit into the clear statutory definition for pensions. And that is why the claim fails.
So clarify me, I'm following you at least. You mentioned a reservation of rights clause, and I was talking about pre-1984 potential vesting of welfare benefits. You're saying it's not statutory, it's something an employer would do. I agree with that. Pension would be statutory. But there was no reservation of rights clause prior to 1984. So the question is when or if, as construed in this welfare benefit, the right to life insurance vested, because it appears that PPG is arguing that there's no vesting prior to this retirement.
We certainly believe that before a surviving spouse begins receiving a payment stream under this plan, which clearly is the case now because all these individuals went over to Axial, they weren't yet receiving that benefit. So we certainly agree that before they actually enter that status, there is an ability to terminate the benefit because they're not receiving it. That's the same for a life insurance policy, Your Honor. Until you actually receive the life insurance proceeds, PPG couldn't come to that person and say, well, now that the retiree is deceased, we've changed our mind, give us that money back. We certainly would acknowledge at that point that the payment has vested in the sense it's been provided to the participant. But before that happens, Your Honor, when someone is just in a retiree status and they've yet to die or their spouse is yet to begin receiving the payment streams, I think ERISA is very clear that you have the right to say, we're no longer going to provide that benefit if it's non-vested. And that's what the...
That's my question. Prior to the reservation of rights clause, do you contend that the life insurance only vests upon death?
Yes, I would say that, Your Honor. And the other thing I would say is that...
They had to die before 1984
Well, if they had died before 1984, none of them were retirees before 1984, which was my next point, Your Honor. None of these individuals who are in this putative.
But adding to what Judge Wynn mentioning, there was a reservation of rights in effect prior to 1984. It was in effect prior to 1969,
right.
And then it was scrubbed.
That's right.
It was scrubbed out.
That's right.
And it was removed because in the company's mind, it caused doubt in the minds of retirees, and the sense of security that retirees look for was absent. And it was removed because the legal ability to enforce the reservation of rights was in doubt.
Correct.
According to the company's after discovered records. Why'd you hide all the records?
We didn't hide any records, Your Honor.
Oh, you didn't?
We did not.
Well, it didn't show up until after the summary judgment briefing had been completed.
Well, I can answer both questions. If I could answer your question about 1969 first, and then I'll get to the second question you raised, Your Honor. I completely agree that that's what the records say about what was the state of affairs in 1969. And I'll say two things about that. Number one, the legal uncertainty that existed in 1969 about whether reservation of rights clauses could be enforced was resolved by Congress in 1974. So the fact that
ERISA took care of this for you.
Yes, it did. Well, not for me personally, Your Honor, but it certainly did take care of
I kind of thought you'd say that.
the legal uncertainty that the company had referred to back in 1969 when it removed the reservation of rights clause. By the time it reintroduced it in 1984, the legal certainty as to whether a reservation of rights clause could be enforced was eliminated. And they weren't the only company.
Why'd you wait 10 years to reinstate it then if it was all ERISA?
Well, Your Honor, I don't know that there's any facts in the record about that. But
there could have been if you ought to come up with the records on time, maybe.
Yes, Your Honor.
No question about that.
Well, I'll answer that question right now, Your Honor. The only records that were missing, Your Honor, were records showing the actual amendment by the Employee Benefits Committee in 1984 to include the reservation of rights clause in the plan. However, plaintiffs have known since the beginning of this litigation that there was no reservation of rights clause before 1984. In fact, they argued that the absence of a reservation of rights clause.
Well, there was one prior to 1969. You disagreed with me.
Yes, Your Honor, but the court considered this and found that that's legally irrelevant to the question of what the vesting.
Which court considered it?
The lower court, Your Honor.
Well, that's what's on appeal here, though.
No, it's not. They didn't.
That's what's on appeal here is whether that's correct what the lower court did. That's what we're reviewing.
No, man, they filed.
That's what we're trying to figure out whether that was correct or not. What the lower court did.
They did. The plaintiffs did not appeal the denial of Rule 50.
On this, I don't think there's deference owed on a summary judgment ruling. We have to look at it, don't we? De novo?
Yes, Your Honor.
Oh, that's
yes.
right. Yeah. And if it's a legal question, we look at it de novo.
Yes, Your Honor.
And a factual question, we look at it in the light most favorable to them.
Yes, Your Honor.
And that vesting sounds like a factual issue to me.
Your Honor, under this court's decision in Pierce, I don't believe it's a factual question because this court has found that the subsequent introduction of reservation of rights language defeats claims for vested benefits. And we don't believe that an act that occurred before the statute that they base their claims on changes that analysis in any way. I don't think there's anything in ERISA that says once you decide to vest a benefit, you can't unvest it. That's the antithesis of what Congress did when it established this difference between welfare benefits and pension benefits.
Well, I mean, you could tie your own hands, at least for people who enter employment under a certain contract or retire under a certain contract. If you have clear language in your plan that says, that shows an intention to vest this benefit, and then you add a reservation of rights the next year, then people who had the previous plan, you've vested their rights. But I think I infer what you're saying here is that language was absent before 1984.
That's correct, Your Honor.
Okay. So, but you agree with me that you can't just add a reservation of rights if you've previously had clear vesting language and somehow absolve yourself.
No question, Your Honor.
You couldn't unvest, could you?
You couldn't unvest someone who's already
if they were
attained.
vested between 1974 or 1969 and 1984, you couldn't take it away from them.
If there was other language in the plan that actually vested the benefits, Your Honor.
And the district court didn't address that.
The district court found that the answer
didn't find anything because it's on summary judgment. But the district court didn't address that point.
Well, I don't agree with that, Your Honor. I think
Okay.
the district court found that.
The district court can't find in a summary judgment ruling. The district court has to accept the facts in the light most favorable to the other side.
Yes, Your Honor.
The district courts don't make findings of fact in summary judgment rulings.
Yes, Your
The
Honor.
district court didn't find. Go ahead.
I apologize, Your Honor. Viewing the facts in favor of the plaintiffs, the district court did not find any vesting language in this plan when the changes were made. There are cases that this court has considered where someone became disabled, so they're receiving benefits under a benefit plan, and this court has said they vested in the benefit because they've actually gotten into the requisite status, and so now you can't take that stream of disability payments away from them. It's similar to the question that was asked about when someone becomes when they die and they receive the benefits. There is that's the vesting. It's not always going to be at the same point in time. So anyway, I'd like to move on to the other argument raised by plaintiffs, unless the court has any further questions. As to the contract claim, again, this court, plaintiffs argue this case as if somehow this is some blank slate, and this court's actually considered these same issues in a number of cases. On this question of whether there was a termination in 2013, this court in the Sedgman decision considered this very scenario where there were benefit obligations that were transferred to a different company. And this court found that there was no violation, that you could not hold the transfer company liable for the subsequent termination of those benefits because the transfer itself did not alter the entitlement to these benefits. The obligations went to the new company. The new company continued to provide those benefits. That's the same thing that happened in this case that this court addressed in the Sedgman decision. And it found that the claim for benefits or that the divestiture of this transfer of these benefit obligations didn't change plaintiff's position with regards to the benefited issues. And the same is true here, Your Honor. They continue to receive those life insurance benefits or had the ability to potentially receive them for 3 additional years until Axial made an independent subsequent decision to terminate those benefits. And because these benefits were not vested, there was no delegation of contractual duty to Axial that would flow back to PPG once Axial terminated the benefits. And we cited in that regard the Sixth Circuit's decision in Sengpil, which specifically considered the argument they're making that somehow we had to get their consent or there was some improper delegation. So these are not issues. This case is not a unicorn, and these are issues that this court and other courts have considered. And even if it were to be that this case was the transfer of the benefits was considered a termination, the fact remains that the plan at the time in question, as I mentioned ago, reserved the right to modify these benefits. So when plaintiffs say PPG didn't amend the plan or didn't take advantage of the reservations of rights clause, it's a straw man. There was no requirement to amend or terminate this plan in order to transfer the benefit obligations because the reservations of rights language itself said that PPG could amend or terminate the benefit plan or a part of the benefit plan described herein as such applies to participants. And it further stated that PPG reserved the right to amend, modify, or terminate those benefits at any time and for any reason.
And it couldn't do that if it had been vested pre-1984, though.
That's right, Your Honor. They couldn't have. I agree with you, but we believe the facts in this case show that they're not. And so this idea that they're saying, well, PPG didn't amend or terminate the plan runs into their own contention that PPG wrongfully terminated their coverage during the actual transaction. The reservations of rights clause says PPG could terminate these benefit plans, as I said a moment ago. And given that language, PPG did not need to amend or terminate PPG didn't need to amend or terminate the plan in order to terminate the plaintiff's participation in this plan. It already had that right given the breadth of the reservations of rights clause. So this idea that there was a failure to amend the plan or terminate the plan is a straw man. As to the additional arguments that they raise, it just fails to recognize that if you're complaining about disclosure obligations under ERISA, there's some requirement that you show reliance or prejudice, and they've made no efforts to make any such showings here. They're just simply trying to argue that somehow there was this failure contractually to provide these benefits after Axial ceased to provide them. But because these benefits were not vested, as we've argued, Your Honor, that there was never a renewed obligation by PPG to come in and continue to provide these benefits to the individuals in the putative
It
class.
all comes down, at least in terms of issues of whether there was a vesting before 1984. And you have this language in there, this guaranteed lifetime income language, and there is no reservation pre-1994 in it. And it really does beg the question is, does that create an issue of fact, or does it create a situation where we have to have more to determine, was there in fact a vesting here?
Yes, Your Honor, I think the answer to both of those questions is no. First, as to the presence of the guaranteed language, we cited numerous Circuit Court of Appeals decisions that have considered this very same dynamic of having guaranteed language in a plan that also has reservations of rights language. And the Sixth Circuit, the 10th Circuit, apologize, Your Honor, I believe we cited cases from the 3rd, 6th, 7th, and 10th Circuit, all of which considered vesting language. The benefits are for life. The benefits are until death. But in each of those cases, like this one, there was also a reservation of rights clause in the plan. And because ERISA requires us to read the contract as a whole, the courts reconciled the language and found that there was no vested benefit.
That's where you're confused. You said in each of those cases, there was a reservation of rights clause, but there was not one in this case before 1984.
Yes.
That's where I'm getting confused. You keep bringing that up, the reservation of rights clause. There's not one before 1984 during the time you have this guaranteed income language in there. And in any of those cases, and so it seems like to me, we circle back on this vesting question, and it's just not there.
I think, I'm sorry, I didn't mean to interrupt you.
No, go ahead.
As I say, I think we've already answered that question though, and that is the Pierce case from this court answers that question, Your Honor. The fact that there wasn't a reservation.
Answer the question as to no reservation of rights clause pre-84.
It does, Your Honor.
Maybe you could clarify for the court what we're talking about and what the guaranteed language. Is that just in the spousal benefit, or is that the entire life insurance policy?
That's just the spousal benefit, okay, Your Honor. It's not for the other retirees. There's no guaranteed language in any of the benefit plans for anyone else receiving these benefits, just the spousal population. But what I would say, Your Honor, is that Pierce does answer this question, well, with all due respect, Your Honor, in that case, there was vesting language before the reservation of rights clause in that case was added. So, I mean, it lines up under the same fact pattern here where there was a period of time where there was vesting language. The employer subsequently introduced a reservation of rights clause into the benefit plan. And this court found that the introduction of that reservation of rights language allowed the company to terminate the benefits. And in particular, on page 30 of that case, there's a long passage that we cite in our brief at page 26 that specifically addresses this factual dynamic of having vesting language that's later encumbered by a reservations of rights clause. And in fact, this court specifically noted that by the time the challenge action was adopted, the right to change the medical benefit provisions was quite clear in light of the subsequent introduction of the reservation of rights clause. So, Your Honor, I do believe that answers this question of what do you do with vesting language that later gets encumbered by reservation of rights clause. This court has said in Pierce and Gable that you look at the benefit plan that's at issue when the challenged action takes place. The challenged action in this case took place in 2013. And by that point in time, there had been a reservation of rights clause for almost 30 years in this benefit plan. And so respectfully, under the precedent of this court, we believe that there can be no vesting given that sequence of events. And I see I've taken more of my time than I was permitted.
Don't sit down yet. I got a couple more questions.
Okay, yes, Your Honor.
Stay here with us till we get finished with that. I ask you the same question I asked your opponent here. How many retirees were affected by the termination of the life insurance benefits?
I believe she's right that it was about 1,000 retirees who were affected by that.
And how many were already working for PPG in 1969 or hired between 69 and 84?
I believe most of them, if not all of them, would have fallen into that category, Your Honor. But I would also say that none of them had retired before the introduction of the reservation of rights language in 1984. If you have nothing further, thank you for your time today, and we'd ask that the district court's the lower court's opinion be upheld. Thank you.
Thank you, Mr. Torres. We appreciate it. Ms. Davidson-Welling.
Thank you, Your Honor. So I want to touch on a few of the points that Mr. Torres mentioned to you. First, Mr. Torres misstates Pierce. That case, the plan always had a reservation of rights in the plan. The issue was that it hadn't, the reservation of rights in the plan had not been disclosed in the SPDs, which were separately issued. So that case is not on all fours with this case at all, and really says nothing about what the circumstances here where there wasn't in this critical period a reservation of rights, and the reason for that was because it had been removed intentionally to vest benefits. So, and also, similarly with Sedgman, that case also does not control the analysis here. That case, simply said that, look, benefits just didn't vest as a result of a divestiture. The plaintiffs there weren't qualified under the terms of the plan, and that nothing changed when they were transferred. Again, not controlling, and really doesn't sort of meet the issue squarely on. So with respect to sort of the points that were raised, ERISA doesn't take away vested benefits. The benefits here were vested in 1969 through 1984, and ERISA was passed in the middle of that period, but ERISA didn't retroactively go back and take away contractual rights that people already had. Right, those rights were already vested, and ERISA didn't take them away. And the plan that
it sounds to me like if vesting has some semblance of being a factual issue, that you all are 180 degrees apart.
We are absolutely 180 degrees apart in the sense that we believe that very firmly that there was vesting here in this period, and that there's a clear manifestation of that.
Mr. Torrey says nothing's vested.
That is what he says.
Stay right there. You say you are different, but it sounds like you're different on the conclusion. What facts are you disputing? Where are you differing on the facts of what would lead to that conclusion?
I do not necessarily believe that the distinction is on the facts. It's on the application of the law to those facts.
Well, I want to make sure you answer Judge King's question. He said it looked like more of a factual determination as to what is vesting, that you had differences. And I'm asking, is it factual or is it a legal question?
So
that's the heart of what Judge King is going at here. You said we're 180 degrees apart, and that was all sounding good until I was trying to figure out, well, where are you different? Other than the ultimate determination, this is vesting. He says it's not, and that's the difference. But when you get up into this area, the facts, I'm asking, what's disputed?
What is disputed? The factual record is what is available, what happened in 1969 through 1984, to the extent that the records exist, it is not disputed. What is disputed is that, we think that the inference from that is a very clear manifestation. They deliberately relinquish their rights, and that establishes vesting.
So then this was a proper question for summary judgment, you were saying. There's no dispute in terms of the facts, but the ultimate determination is wrong as a matter of law.
The ultimate determination was incorrect as a matter of law.
So you don't want a trial, you want a ruling in your favor on the word vesting.
We do, Your Honor.
You may be biting off more than you can chew.
Well, if to the extent that that it could go either way, then if there's a fact.
Well, if it's a factual issue, or if it's a mixed issue of law and fact, It's something for a jury to decide. The way I've always understood how these legal procedures work.
And if you go back to the facts and you started saying, well, you know, the question is whether in this instance, was it vested based on the fact that this had a guaranteed income clause or not had? Does that make a difference? Whereas the different facts here that are being relied upon would change the outcome. Then we got a summary judgment problem. Where you are is a question of law, which is squarely before this court. We don't send anything back because you're telling me all this is undisputed, the facts that lead to it. Is that correct?
Yes, I mean, the factual record is undisputed. The inference from that may be in dispute, but the facts are not disputed. The legal application of
Well, the ultimate fact is disputed.
Correct.
If vesting is an ultimate fact, it's disputed for certain.
That is for sure.
Here between
Yes.
the two sides.
If I might, if you have further questions on that, I'm happy to answer them. Otherwise, I have a few more points.
You go right ahead.
So I just wanted to
Oh, I'm sorry.
to maybe put a bow on it. So you're saying the parties disagree about the correct interpretation of the contract.
That is correct.
And we're trying to interpret the contract to determine whether rights vested or not. And that's not a factual dispute.
That is the application of law to facts.
Of law to
that-
this contract.
That are not in dispute. The inferences may be in dispute.
Thank you.
Now, with respect to the question, there was briefly, Mr. Torres touched on, what a pension benefit, who that pays to, and cited the language of the pension benefit statute. In Re Lucent, the case that they cited in the Third Circuit specifically recognized that the statute says that it doesn't matter who the pension benefit is made to, that it doesn't matter the identity of the recipient. What matters is the nature of the benefit and whether it pays retirement income. Here, it's undisputed that it paid retirement income. It was a pension benefit, and it was non-forfeitable by statute.
Sorry, did you say it's undisputed it was a retirement benefit?
That it paid retirement income, right? The plan administrator testified when deposed that the SIB.
Oh, I heard her testament. Gotcha.
Right, provided-
Okay. You're not saying that they actually have conceded that this is a retirement benefit, because then we would just have wasted a bunch of time.
Right.
Okay.
They don't.
Thank you.
Yeah. And with respect to we also disagree on whether, what the plan required in 2011, right? That plan, right? It doesn't permit them under the terms of that plan to terminate coverage. Now, Mr. Torres says, hey, look, we had a reservation of rights clause in the plan, but it's undisputed that they never used it, and you have to use it. Like the ERISA, written plan documents are the linchpin of the system of administration that Congress set in place in enacting ERISA, right? And this court's precedents are very clear that implied amendments to ERISA plans do absolutely nothing to change the terms of written coverage. We cited the Health South rehabilitation case, which said that there is not a single case that defendants have cited where a court said it was that they could just disregard the written plan terms. ERISA runs based on the plans, and the statute says fiduciaries have to discharge their duties in accordance with the written plan instrument. The plan must be administered in accordance with its written terms. If PPG wanted to terminate coverage, which was not an event that it had listed in 30 years, it had to give notice in the SPDs, and it had to amend the plan. PPG had to comply with the plan as written or amend it, and it did neither. Right? Even if it had a reservation of rights in the plan, it never used it. The plan administrator testified to that. That was a violation of law. And ERISA requires that any changes to the written plan have to be made by amendments and following the formal procedures. And there is nothing that they just didn't do that here. It's undisputed. And that's another basis on which to find liability on count one. That is separate. It doesn't even depend on vesting. So, I think that just sort of, going back through here, you know, that this, you know, this is a really unusual case because of the fact pattern. And it really, you know, the undisputed facts show that the plan was amended to take out that reservation of rights. There's nothing like this. And that act was a waiver of a contractual right. That was, and you know, the language in those committee minutes did say, well, you know, they weren't sure if they could enforce it, but it was still a right that they took out of the plan. And in the next 15 years, they did, you know, they issued an SPD pursuant to ERISA, which is the 1981 SPD, and it did not have any reservation of rights language. They knew about ERISA. It still didn't have any reservation of rights language, even though other employee benefit plans in that same booklet had reservation of rights. The clear inference from this evidence is that benefits at that point under the life insurance plan were vested. That they were vested. When you take this evidence and look at it, it shows that it was vested. PPG believed it was vested. When they talked about putting the reservation of rights back into the plan in 1984, there's an acknowledgement there that they knew that they didn't have that right, and they needed, you know, if they wanted to be able to do it as to new hires, they needed to put it back into the plan. That they had already granted vested benefits. They couldn't change that. The reservation of rights they added in 1984 could only affect, you know, new hires who hadn't already been promised vested benefits. I think I might be out of time. I would just ask that, you know, we ask the district court's counts on 1, 7, and 8 be, you know, be reversed, and that judgment be granted on the SIB counts in retirees' favor, and remand for class certification and other, you know, other things consistent with this court's opinion.
Thank you very much. We appreciate it. It's good to have good lawyers here from the 7th Circuit and the 3rd Circuit. We're very pleased to have you. 4th Circuit has a unique practice that we've followed for years. At the conclusion of each argument, we come down to the well of the court. The judges, 3 judges do, and shake hands with the lawyers and compliment them on their presentations. We're not doing that right now because of the circumstances with the pandemic. So I'll just tell you that from the bench. We're very pleased to have you here, and thank you very much for your service to your clients and to the court.
Thank you for the opportunity, Your Honor.
Thank you. Thank all of you.
And with that, we will take this case under advisement. And need a break? Need a break? And we will call the next case. Our third case today is number 21-2022. Ms. Jump.
Yes, Your Honor.
And you represent Mr. Mowry?
Yes, I do, Your Honor.
Pleased to have you here. You may proceed when you're ready there. Take your time.
Thank you, Your Honor. May it please the court, my name is Christina Jump, and I am here on behalf of Nathan Mowry, the appellant here today. Traditional equitable principles require the balancing of public and private interests. That's what the Supreme Court said in Webster v. Doe. And more recently, the Supreme Court held that a plaintiff experiencing a deprivation of a right must of necessity have a means to validate that right. In Uzagbunam v. Pruchevsky, and my apologies if I did not pronounce that particular case name correctly. Restricting judicial review to the degree that absolutely no judicial consideration would be available is not what the Supreme Court favors. And this court, most recently in Wikimedia Foundation v. NSA, recognized the need to strike fair and just balance between national security and the protection of personal liberties. That's why we're here today, Your Honors. Nathan Mowry, our client and the appellant here today, has security clearance that he had prior to the events relevant to this particular matter. He was a contractor with NGA and was offered a position to become a direct employee and then CIA assignee. This all went well until during the mandatory psychological evaluation, which was part of the medical clearance. He was asked why he had stopped drinking 2 years previously as a follow-up to one of his earlier answers. And he said it's because he converted to Islam. All the questions from that point forward were focused on his religious beliefs, his religion, and his practice of his beliefs. Appellees described this as a medical clearance process, which included the psychological exam. Mr. Mowry's security clearance was not denied or revoked. In fact, appellees specifically went out of their way to inform him by email that this is not a denial of a security clearance. And yet he was given no recourse, whether by administrative or judicial means. And unlike all of the cases cited in this briefing by both parties, no reason was identified for appellees' actions regarding Mr. Mowry. Also, appellees have never identified the evaluator or the specific qualifications of that individual, and whether that person administering the psychological exam ever made a particular recommendation and on what basis. All prior cases cited to this court do identify at least a reason, even in the national security context. In Egan itself, negative information had not been previously disclosed. In Hagab, the plaintiff's new wife had activity that led to concerns by the agencies. In Campbell v. McCarthy by this court, there were allegations that the plaintiff had acted as a stalker and also that he brought recording devices to the facility against regulations. In Reinbold, the plaintiff was determined to be paranoid and delusional. In Becerra,
Have you brought sorry, over here. Have you brought a due process claim along these lines that he was entitled to be told the reason? And is that before us, or do we still have the preliminary sort of question of whether we can even get there because of Egan?
Your Honor, we do not have a due process claim, a separate constitutional due process claim in this lawsuit. And much like the plaintiff in Egan did not. There was no standalone due process claim in that case either. And I do believe that the first thing we need to do is determine whether we get there, whether we go any further. As the court is aware, in this case, the district court granted the motion to dismiss based on subject matter jurisdiction on the 12B1. There was also a 12B6 filed, but that was not considered by the district court, and there was no ruling made on that basis. The appellees point to cases like Foote and Sanchez.
Dismissal here was without prejudice, was it not?
The dismissal here was without prejudice and with the notation by the district court judge that the discussion which occurred at oral argument before the district court, the discussion regarding potential amendment to include a due process claim would, in the district court judge's mind, be futile. We obviously disagree with that and would request, among other things, that should this court affirm on the existing bases that we be entitled to remand to bring a constitutional due process claim by way of amendment, as that would still be a timely claim.
You're asking us for permission to amend the complaint?
We did not at the district court level, Your Honor, because the discussion had occurred during the oral argument before the district court, and the decision of the district court, again, listed, even though there had not been a proposed amended complaint submitted for the judge to consider, the decision of the district court specifically listed in a footnote that would be considered futile, and the district court would not entertain that. Based on that basis, we went straight to appeal.
We're not in that business either. I mean,
I'm sorry, Your Honor?
I said, we're not in that business, I don't think either, let you amend a complaint if you got up here. I mean,
Your Honor, I would argue that bringing a constitutional due process claim is something that Mr. Mowry could do in an independent action right now that would still be timely and in the interest of judicial economy, continuing it with this case, as opposed to starting fresh in a brand new one, would benefit all parties involved. But he could bring a fresh claim if we came to that and if that were necessary. Again, though, we don't believe that the precedent leads to that, and that the application of Egan to the facts of this case lead to that outcome.
Let me ask you, how is it that the decision to halt security processing, not essentially a decision that equates to the denial of security clearance?
Your Honor, I would agree that it has the impact on Mr. Mowry of equating to a denial, as if he couldn't continue the processing, then he couldn't take the position that he had been offered. However, what has not happened here is the exercise of any predictive judgment. Unlike all of the other cases that are briefed by both parties in this matter, what happened in each of those, the agencies identified a particular reason, even in the night for revoking or.
Isn't the predictive judgment going to national security concerns?
Your Honor, we don't know here on this one, because what was addressed was simply that they were not going to continue the processing, no reason given. And Mr. Mowry was specifically informed that this was not a denial of a national security clearance, that he was welcome to and should list on any future application, and he had not been denied security clearance.
Wasn't that to his benefit, that you would not want to go forward and have it put on a future application that you've been denied a security benefit?
He certainly would not want to put that on a future application, Your Honor, but where it matters here is that provides, near as we can tell, indication that this was not based on him being considered any sort of a security risk. He continues to hold security
I thought
clearance
this was
today.
not considered a security clearance. It's considered a separate additional security requirement or whatever the language is. So, and you just pointed out he has a security clearance. So the reason that he was told you've not been denied a security clearance is because he hasn't. He's been denied, he didn't satisfy this additional security requirement, but it's not a clearance. And that's the whole discussion is, does Egan apply to this category?
Correct.
But it's just because it's just factually not a clearance.
That is correct, Your Honor, in that this was the additional medical requirement on top of the security
Right.
clearance that he already had. But the cases which extend Egan into additional context such as that, again, they all have where the agencies have identified a reason for denying or not process or revoking the status that is at issue,
Where
and
does
that's
that
not
come-
present here.
Where does that come into the Egan analysis? The fact that they were given a reason rather than just told, you know, we're assessing security and trying to determine whether someone can be trusted with, you know, we're making a future prediction about whether they can be trusted with the secrets of our country. And, you know, for reasons we can't tell you, you haven't satisfied it. Where in our analysis do we factor in what you're talking about, which is that he wasn't told the specific reason why he was found potentially untrustworthy or not of a current mental state to be able to fulfill this obligation, although he could apply again in 1 year?
Your Honor, two things as that. First of all, we don't know that he was found not to be of an appropriate mental state. Again, the particular factor that the stage where he was not denied. He was not told that you don't meet this. He was simply told we will not continue processing. We will not go further with the processing. So we actually don't know that he was
You're
considered.
saying
to
there
be
was
a
no
risk in any way.
decision.
I'm sorry?
There's no decision made.
Correct. There was no decision made. They basically
I'm
sat
wondering
down.
how
the
we
road.
got even got jurisdiction here. That you don't have a decision to denial, and you don't have a dismissal with prejudice. What are we doing here?
Your Honor,
What do you want us to do? Issue an injunction or something?
we have requested equitable relief. We have requested injunction in the pleadings. Your Honor, what I would say is
Tell them
that
to complete the process?
what we would like to do is complete the process. We will either
Well,
complete
you
the
want-
process on that, Your Honor, or remand to the district court where,
Did you ask Judge Ellis for an injunction?
yes, Your Honor.
He did not?
He did not rule on that. He
He
ruled that
didn't
there was
rule on
no,
it. Well, you can't appeal that.
I'm
He
sorry.
didn't rule on it. What, how you got jurisdiction for the appeal? You don't have a final order then, doesn't sound to me like.
We have
He
what,
didn't deny your injunction request, and he didn't issue a final order.
Right.
He dismissed it without prejudice.
Your Honor, we have a final order from the district court that we believe to be in there for the reasons that you've just articulated. We don't believe that it was appropriate. We believe what should be appropriate is to remand it back, and then we can proceed with the case, because if there was no national security decision, then there is no national security protective cloak that applies to the actions of appellees here. They don't get predictive judgment if they
He just
didn't make
basically
a
said
judgment.
He basically said that Egan case says this is not Article 3 business. This is Article 2 business. Security clearances. It's a matter for the executive branch. But
Correct, Your Honor. And since there was no decision made, we dispute that would apply, that Egan would apply, and that would extend
he didn't have
under
a
the
decision
facts.
to review. You're saying he had no decision to review.
Correct. There was no decision to review. There was no predictive judgment
Counsel, I'm
exercised.
confused because in the appendix, the CIA, in this declaration, they say, based on the psychological examination, the psychologist made the predictive assessment that there were concerns about Mr. Mallory's ability to meet the standards set forth in 704.2. As a result of the assessment, the CIA terminated Mr. Mallory's personnel security processing in May of 2017. So they found there was a predictive judgment, so they terminated processing. Where's the lack of finality?
Your Honor, what I would say is different here is, first of all, that he was not told we're denying the processing or we're denying the next status. He was told we're halting it. We're not going to move forward with it.
Stopping. Halting can mean stopping, terminating, not continuing.
We're not moving
You want us to
forward
read it as like
Correct.
pausing, maybe we'll pick it up again one day, but there's nothing in the record to suggest that.
Your Honor, also what did not happen here that has happened in every other case that has examined these similar situations with additional requirements that need to be evaluated, as this court did in Hegab case. In that case, there already was security clearance, and what was evaluated was the revocation based on an additional evaluation. And what did not happen here is that here we don't know that the person doing, whoever it may have been, do it after the fact with the declaration that's provided. A person who was not involved in the process says, I read the file. The way that I read the file, I believe that there were some concerns, and I think that was the basis of it. Every single other case, again, Reinbold, Campbell v. McCarthy, Foote, Sanchez, Egan, Hegab, and Becerra all identify that either the age status at issue on the basis that where there was a psychological exam involved, that the examiner, first of all, was identified. That's one of the requirements under Egan, that they be identified and their ability to do this be specified. That's not happened here. And there was no statement made in anything provided by appellees that this particular examiner recommended that he was any sort of a security threat.
Why does it matter who recommended it if we know that the CIA, someone at the CIA who's qualified to do this, determined that there were concerns with his ability to meet this ICPG, which is all about trustworthiness, your mental ability, should we let you have the nation's secrets? They made a predictive judgment based on that, someone, and decided to terminate processing his security requirements and said, try again in 1 year.
Your Honor, if I understand your question, or I'm sorry, could you just restate the question so I understand where?
You just asked a good question. I probably should just put a question mark at the end of that. I'm confused about why you say, I mean, we have here that someone at the CIA has determined that Mr. Mowry doesn't meet, they made the predictive judgment that he's not going, at this stage, he shouldn't be trusted with secrets. He should try again in a year. So they terminated his processing. How is that insufficient? How is that different? Where does the requirement come from that you're talking about that, no, you only get Egan if you identify the name of the person who made that determination and, give us, I guess, the particulars of what they said?
Your Honor, and it's not even necessarily going to the particulars of what they said, but a broad category of what they said and who said it, who made
No, I'm asking, where does that requirement come from?
That is one of the requirements in Egan that was examined in great detail in Foote,
Well, that was the argument in Foote. They were saying, well, this person, it's not a predictive judgment, yada, yada.
In the Foote case, what was the reason that the decision was affirmed by then Circuit Court Judge Kavanaugh in Foote was that in that situation, they identified who made the decision, what the qualifications of that individual were, why that individual met the requirements of the language.
That's not why Justice Kavanaugh upheld it. So he looked at the facts and he said, this is just like a security clearance. They're determining trustworthiness. They're determining your judgment, your ability to protect sensitive information. And we know that's what 704.2 is all about here. And that's what Mr. Mowry was found not to satisfy.
Your Honor, what I'm saying is that in this case, we don't know who the individual was and what the qualifications were. We have broad language in a declaration that anybody that we would say, please go evaluate this person, would by definition be qualified. But we don't know what the qualifications were, as opposed to examining the specific individual's qualifications, as was done in Foote.
I'm not sure where Egan requires that. I still don't see that. I don't want to belabor it because I see you're past your time, but you haven't really told me where Egan requires this specificity.
I would be glad to address that with the specific language on rebuttal, but in the Foote opinion, they do rely on that as being the second qualifier of Egan.
Let me ask you this. If we determine this psychological examination failure to pass, which the CIA liaison indicated is in the complaint, failure to pass, that's predictive judgment. How does that affect your case if that determination is made right there?
If the determination had been made and had been communicated at all.
I'm saying if we determine that,
if you determine
is
that
sufficient to be a predictive judgment, the psychological examination, along with the fact that he did not pass, which he states in his complaint, and the CIA liaison says, if it's predictive judgment, then what happens?
If there was predictive judgment exercised, then that would trigger the application of Egan. We don't believe that under the facts from Mr. Mowry that did happen here.
Understand that distinction. So let me ask you one question before you sit. That is, what does the failure to grant an additional security requirement entail? In other words, is that a physical work site prohibition or what? I mean, what is it to not get that?
Your Honor, what happened with Mr. Mowry is that, first of all, his staff-like access had been temporarily suspended pending this processing. And when it was not completed, then he did not have access. He was seated at a desk.
To what? Information, systems, program, or inside?
Yes, as to parts of inside, yes, as to systems, yes, as to information
He
and
doesn't have a
programs.
security clearance to go.
He did not have access to any of that because he could not work on what he had been working on before.
But is it the same as not having a security clearance is what I'm asking.
In this situation, it had that impact on him because he was seated at a desk on a different floor in a different area, and he was given a brand newly created position that had no duties, which involved periodically doing filing and other administrative
Go back to my
acts.
earlier question. So does by halting this additional security requirement process, did it in effect deny him a security clearance to do those things, to access systems, to go in and get information? Did it do that?
That is the impact that it had on Mr. Bowery. Yes, it had that effect.
Why is it not equal?
Because it's not the predictive judgment made. Egan is there to protect the predictive judgment, not the impact. It's there to protect the decision made by the agency that is deemed
You
to
say the
have had.
psychological exam and the fact that he didn't pass it, the fact that CIA liaison indicated that there's predictive judgment that is not.
You know, the way that I read that is that you had somebody coming in to see, after the fact saying, well, now that I look at the file, the way that I see it is this. There's nobody, unlike all of the other cases, who said, I made this determination. I am making the predictive judgment, or somebody saying this individual made it, and we can back up who it is, and we can back up their qualifications to make it without getting into why they made it. We can back up their qualifications to make it, and we can identify that they did make the decision, as opposed to here, where all that we can identify is that Mr. Mowry was told, we're not going to finish. We're not going to move forward on the processing. And that impact on him as a practical matter ended up being the same as if his security clearance had been revoked. But it is not a decision that was ever made, as was communicated clearly in writing by appellees. That is not a decision that was ever made by appellees regarding Mr. Mowry.
I don't do this often. I don't ask this question, but I want to get your thoughts on it. What do you think the Supreme Court would do on this case right here? I mean, given what the indication of we don't want you going into national security, it's an executive branch. And I mean, it's not something we need to be worried about what they would do, but there are clear indicators here. And I just don't see very much supporting you in a case that goes to the Supreme Court. Do you? I mean,
I do, Your Honor, and I see that because of the Supreme Court's opinion in Webster v. Doe, which came after Egan and came, I believe, 6 months after Egan. And in that case, which was not a Title VII case, but the Supreme Court referenced Title VII actions as examples where rummaging through some of the same facts did occur, but that was okay because there were safeguards put in place, which is what we were asking the district court be permitted to do, is utilize the existing safeguards that are in place, such as in-camera review and sealing documents and protective orders. And the Supreme Court in Webster v. Doe found that those protective measures that exist, the safeguarding measures that exist, were sufficient for the case before it, which was a due process one, but it referenced specifically, this happens in Title VII cases as well, that was appropriate to allow to happen with those protective measures in place. And that is the reason that what happened here, I mean, if we look at what's happened since, what happened here is that you have in the Fazaga oral argument before the Supreme Court, Justice Sotomayor stated, I don't know where in any of our jurisprudence we've ever suggested that in-camera review by a judge threatens national security. And I believe that's exactly telling us how they would look at this, that allowing those protective measures to take place would not be a threat. Justice Breyer also stated in that same argument, in that same oral argument, that courts should be able to look at information and there should be a way for courts to decide how to address a question of national security concerns. Not that it should be just a black box closed book because we said the magic words. With that, I'm going to sit down and reserve any remaining time that I have for rebuttal at this point.
We're giving you plenty of time.
I'm sorry?
We appreciate it.
Thank you.
Let's see what the government has to say. Ms. Levinson?
Good afternoon, Your Honors. May it please the court. My name is Rebecca Levinson.
and I represent the National Geospatial Intelligence Agency and the CIA director in this case. In order to take a new position with the NGA in which he would be accessing CIA workspaces and CIA systems and information, plaintiff was required to satisfy the CIA's security requirements, which included a psychological examination. Now, plaintiff knows who this psychologist is because he met with that psychologist, and that psychologist's predictive judgment, as the United States Supreme Court has stated in the...
Why did nuance of words here that, you know, we're not denying you security clearance when it looks to me like it's equate to everything that looks just like you've done that, but they said, no, we're not doing that. We're not denying you security. We're just halting the process.
Your Honor, there is a significant difference here that was touched on in some of the colloquy with my colleague. The ramifications here were different. This is what CIA determined, is that plaintiff had not met the CIA specific psychological examination requirement that it had put in place and allowed him, after a year during which he would be fully employed with NGA, to reapply for that position. He did not lose his security clearance. As his own complaint shows, he retained his security clearance, and therefore, if he wanted to apply for another job that required that clearance...
The short answer is you're doing him a favor?
Not that we're doing him a favor, and so as much as the ramifications here are different.
Or what?
For him.
I'm saying you're doing him a favor.
Your Honor, I certainly think that the email limited the ramifications, the personal ramifications to him, to a job with the CIA. And I would note that in any future security clearance application that plaintiff would have to submit to another government agency, had his security clearance actually been revoked here, he would have to report that revocation, which is pretty significant in any future adjudication.
Let me ask you one question, ma'am.
Certainly.
My colleagues, and that is, Egan seems to, it draws what I think is an approach the court looking at separation of powers, and it determines this is something courts don't have any business in, the security business. Very reasonable. I mean, you just don't, you can't have courts just delving into whether or not the CIA can give a clearance the whole bit. But it sort of dealt specifically with that. And it seems that courts have kind of broadened. Is it your view that we should look at Egan in a very narrow way? Because we do have instances, Title VII being argued here, that he's being discriminated on the basis of his religion. It could have been race, could have been sex, could have been whatever. Egan says, if it's security, national security, we don't belong in that conversation. I mean, that's a kind of odd thing, but national security is very powerful. It's very powerful. But when we begin to expand it, we are creating opportunities. I hate the word abuse, but opportunity to do something other than what the Supreme Court wanted us to do, and that is the pure separation of power. When we begin to look at, well, it didn't deny security, they just halted the process. And if the halting of the process was due to his religious beliefs, how is that something Egan intended to reach, that you can halt it for discriminatory reason? Once you get into it, we're not going to ask why it is. I mean, you see where I'm going? I mean, that's the kind of concern here is where are the lines drawn around Egan? And it seems to be, if you go into the merits of it, and if that's it, then it seems like, which we don't really get into, it seems like you really ought to start out, did this go to the merits of it? Maybe that's where the predictive business and all of that goes into it, but if you can.
Yes, Your Honor, certainly. And I would start with the word halt is plaintiff's framing. He received an email that said, we've made a decision to terminate your security processing. Based in the declaration that we submitted, our position is certainly that the CIA decided not to allow him to start the assignment because he did not pass the mental health examination. But even the word halt is very similar to the word suspend, and the suspension of a security clearance in analogous circumstances has certainly come under Egan analysis and has been roundly found to fall well within Egan. Title VII, on the other hand, this court has regularly determined that Title VII does not contain the express congressional belief that these national security decisions deciding where agencies decide what individuals should have what access to what information should come under Title VII's reach. So there's that limitation as well. But as to where to draw the lines, I think the court in Foote actually had a pretty cogent analysis. There's two-part analysis. One, is this the kind of decision that Egan covers? And then Judge Kavanaugh looked to the question of, look to the language in Egan that talks more about agencies having the ability to control who sees their information. And there's a lot of language in Egan that goes beyond the strict term of security clearance and acknowledges that different requirements, different levels of clearance are going to be required for different positions depending on the sensitivity. So then Judge Kavanaugh said, well, this psychological assessment is precisely the kind of decision that Egan asked us to protect because it governs whether or not this person is going to access the agency's information. And then the second prong was, is this person an expert in making this kind of predictive judgment? And looking to the fact that this was an agency-employed psychologist making a predictive judgment about reliability, trustworthiness, the exact factors that are at issue in ICPG 704.2, then Judge Kavanaugh stated that factor was satisfied as well. And it's our position that that analysis should be no different in this case. Every case involves every Title VII or other employment discrimination case that involves Egan involves a plaintiff questioning the motives of the person making the determination. But this court has repeatedly held that looking to the merits of that determination or looking to the merits of any adverse action that follows from that determination is barred by Egan.
How can we make this a simple case in which we can, what's the narrowest way we could write this, to your view, without saying, okay, if there's anything remotely connected with this security clearance, then that's part of the merits. It just seems to me part of the problem here has to do with how you characterize that psychological examination and the fact that he failed it, and he indicates that in his complaint he failed it the whole bit. Do we declare as a matter of law that a psychological examination is in fact a predictive element?
I think, Your Honor, that one could draw even a narrower line and say a psychological examination that is required by an agency in its judgment, in its discretion, and it's quite clear that the agency has discretion to set requirements for what an applicant or employee must meet to access this information. But to the extent that a psychological examination is a requirement for accessing its information, and that psychological examination is performed by an agency psychologist to assess adjudicative factors that would predict the applicant's reliability, trustworthiness, ability to protect classified information or national security information, that predictive judgment falls within Egan's scope.
Do we have, but could it be examined in camera, the basis of the psychological examination that leads to that conclusion that, there's these other factors here? Whereas what we now have, we have simply the allegation he's talking to me, and then he gets to the fact that of my religion, and he gets hung up on it. And the next thing I know, I'm out of there, which all we have in a bear record looks just like he was terminated because religion came up. And so the question then becomes, is there a room or an avenue by which a case like this, a judge could, and we do high security cases, we have special ways in which we protect the information, actually look at it and determine under some standard, is there a basis upon which the psychological exam wouldn't be a Dauber type thing, but it would, which would qualify the expert, but it would look at the substance and see if in fact, okay, it's there. There's something, I don't know, I'm sort of thinking about McDonnell Douglas and all these other cases that we got out there, and there ought to be something there to say, you can't even establish a prima facie case or something more would be established that it was raised because you got these other things in there.
Your Honor, the Supreme Court is quite clear in Egan that to the extent it's a predictive judgment, it's something that a non-expert outside body cannot assess. And this court repeatedly has understood.
Do you really believe that? I mean, we assess everything else. I mean, this court assess predictive judgment is one of the lightweight things that we can assess in terms of, looking at science and elements and how things can happen in there. Predictive is actually kind of dangerous because it really goes into the realm of subjectivity, which I think maybe that's where you're going with it on it. But there ought to be some basis to protect someone because if the facts are true from his perspective, you would never know. If you went in and he started evaluating and he started talking about religion, and then this psychologist go into mind and said, oh, this is all about religion, I'm not going to do it. And that ends it. But you wouldn't know because, he may not have done anything else other than that. Yeah. How is there no remedy for that? That's what I'm asking.
Your Honor, Egan has fully addressed this kind of on the head. It states that there is a general presumption of reviewability, but that presumption runs aground when it hits the concerns that the court was reviewing in Egan. One particular issue is exactly that subjectivity factor that the Supreme Court recognized was the sole province of the executive to draw the lines of, what's an acceptable margin of risk? What are the issues that we typically look to assess the risk that person could pose to classified information? And those are expert determinations that are the executive's province. I would note that and that's coupled with this court's repeated finding that Title VII also stops short at the door of these kind of security determinations, that Congress, this court, as recently as the decision in Campbell and as far back as the decision in Guillotte, has repeatedly found that it seems that Congress has even specifically determined whether or not to bring these kind of determinations within Title VII's reach and then subsequent employment discrimination statutes and has come to the opposite conclusion. So for those multiple reasons, looking at the merits of the decision is something that Egan pretty expressly forbids. And I would note that the prior cases that this court has analyzed in the employment discrimination context and where it hits up against Egan.
And on that, when you say looking at the merits of the decision, something it does, and I agree, Egan does forbid that, but does it forbid when all the basic record indicates it doesn't give you anything except an allegation that it's religion? Does it preclude getting enough to determine it's not just religion, or that could be something else? Or do you just assume that the psychiatrist did ask some other questions? I mean, because in theory, if he walks in there and he asks from day one, what's your religion? And then spend a whole hour or two talking about nothing but religion, and that's all they have, we never will know it. because we're going to assume he did what a psychiatrist would do, and that is asked all other tests and all the stuff. So is there a way to address that extreme abuse?
Your Honor, I don't think there are sufficient allegations of extreme abuse in this case. Plaintiff
but it applies to a case like that. That's my question. It may not be in this case, but if we just say the presence of a psychological examination where the allegation is made of religion as a discriminatory element, we can't even talk about. We don't have a clue what was that psychological other than they said we did one.
Well, Your Honor, first of all, plaintiff himself alleges that the conversation started on a discussion of his alcohol use, which is a completely routine question asked in all kinds of security background investigations. So
well known though, wasn't it known before he even had the other security about his alcohol use, or was that a first time sort of thing?
I don't profess to know what plaintiffs use or not use. But no, certainly.
The instance of what a role a court could play and why it is that in this instance you couldn't, because you're talking about a statutory right, maybe it could be a constitutional claim or right here. And the question is, could a court in the privacy of chambers look at it and say, no, it's not just religion? And that seemed to me that would be sufficient right there.
No, Your Honor. And I would also note that in the record.
You say that stops it all. You say Egan takes care of it all. We don't have any business in this.
Yes, Your Honor. And that's what the Supreme Court says. It's
right line rule, according to the government.
According to the Supreme Court, it says
that's what I'm saying. Yes. But no, you're the one we have before us today. You're saying it's a bright line rule.
Yes, because
we can't do anything.
Well, it's a matter of constitution.
All we can do is affirm Judge Ellis.
That is our position, Your Honor.
We can just say Judge Ellis is affirmed. That's the narrowest way to rule.
Yeah. Yes.
You were asked about that earlier.
Yes.
Is that correct?
Yes, Your Honor. This is a matter of constitutional separation of powers.
Right. We can just say, don't even bring these appeals up anymore, right? That's what you're saying. You're saying we can just write a little policy that says, well, if it's dealing even close with national security, you've been discriminating against race, sex, don't bring it here because there's no remedy that the Supreme Court allows you. Is that what you're saying?
No, Your Honor, I'm not saying that, but I am saying
that.
I'm saying that,
exactly that.
I'm saying that if it falls.
Instead of saying affirmed, we could say dismissed.
Your Honor.
You could say dismissed.
Your Honor,
Article 3, courts have no business looking at it.
And all I'm saying is that the Supreme Court in Egan
is Egan. You're talking about Egan.
Yes, and this
all
court
based on Egan.
But this court has repeatedly.
And it's been the law since 1988 or something.
Yes, and this court has repeatedly repeated that and followed that guidance. Yes. I would also note that for the record, there is a declaration that states that there were other Muslim officers who are working in that space and obtained that.
That makes it look a little better.
All I'm saying is it's not an empty record. It's certainly.
But that's not necessary. You don't need to know there were some others in there. You don't have to know anything other than the fact that you just didn't get it.
But as to
all you need to know is he makes the allegation was about religion. You don't have to know what was in the examination. You don't have to have knowledge that this examiner even asked one question other than religion in his own mind says, I'm just not going to give it on religion and we're going to halt it. And that's the end of it.
And frankly, Your Honor.
True. That is true, isn't it?
Yes, and that's what happened in Foote. That's what happened in Foote. There was, contrary to plaintiff's assertion, there was no reason given in Foote. The appellate court's decision simply says that there were confidential reasons that he was denied, and he alleges discrimination.
What case is that?
The Foote case, Foote v. Moniz. It's the D.C. Circuit's opinion.
We had one here a few years back where some fellow was arrested. Claimed he was arrested by the CIA over in Macedonia and held in Afghanistan in solitary confinement or something for about a year, and then turned loose in Albania. And y'all filed an affidavit and said you can't review anything, and we said we have to go along with it.
I think that's the Albit case, Your Honor.
What's the name of him?
The Albit case, the
Might have been.
state secrets case.
I think I wrote it. But we
Or
decided what
perhaps
we could do.
El
But
Masri.
it sounded terrible.
Yes.
What they had done, they got the wrong guy. I think there wasn't any question they had the wrong fellow, but they.
I just wanted to make a few additional, I see my time is up. For the reasons,
We've been very liberal on the time, so you,
thank you, Your Honor. I just make one or two additional responses to plaintiff. As stated, neither the Becerra court nor the Foote case referenced any reasons that were given to the plaintiff for the denial or the predictive judgment. So I would note that. I would also note that the El Gayani case in the Third Circuit only listed the regulatory reasons for which the plaintiff, the security clearance had been revoked. The declaration here certainly also lists the adjudicative factors that were at issue. Plaintiff did not seek injunctive relief to complete the process below, and he resigned from the NGA before he had the opportunity to retake the, to reapply, to retake the mental health examination. So it's difficult to understand how that kind of injunctive relief could be awarded. I would note that the Webster case related to statutory claims. It had no analysis of executive to power, separation of powers, did not mention Egan in the majority opinion, and certainly did not analyze what happens when Egan's constitutional analysis comes up against constitutional claims. This court in Hagab has said that constitutional claims to just address the merits of a security clearance are not actionable. And I would also note that plaintiff made no formal motion to amend below. That motion is not properly before the court and should not be considered. And although Judge Ellis made note of the unavailability of the claims plaintiff seemed to be making at oral argument, he did not deny any such implied motion to the extent that it could be characterized as one, as futile. For those reasons, Your Honor, unless there's any further questions, we respectfully request that you affirm the district court. Thank you.
Thank you very much, Ms. Levitt. Ms. Jump?
Thank you, Your Honors. I want to begin with just a few clarifications. First of all, there is absolutely no allegation in my client's defense here, and to make sure that we get the record clear, there's absolutely no allegation in this suit that he ever had any issue with alcohol abuse or any problem with alcohol. So I just want to make sure for his sake that we get that clear. It's simply that he was asked a question during the psychological examination as to when the last time was that he had a drink or whether he drinks, and he stated he hadn't had a drink for 2 years.
That matters under the statement of the counsel on the other side. All you need under Egan is to show us a psychological examination. Under these facts right here, there's no appeal. There's nothing you can do about it.
I agree that that is the argument made by my colleague on the other side of the aisle here, and I disagree with it.
Just to say perhaps there was something in the record that might show beyond the fact that his religion was there. It could be, but as she candidly admitted, wasn't even necessary. So we can forget alcohol. Under their analysis, it's not necessary to say about alcohol or anything else. All you need to say is psychological expert denied it in a security process that's been halted or whatever, halted or terminated or not or suspended. That's the end of it under Egan.
Your Honor, I agree that that is the position of appellees in this case. I disagree that that's accurate, but I did want to just clarify factually and on behalf of my client that that does not happen to be an allegation.
I'm trying to understand why you're disagreeing with.
I'm stating that the alcohol, any allegation as to alcohol abuse
Not alcohol. I'm disagreeing with that ultimate statement here, which is the killer. That's a killer statement. You do realize that, don't you?
Your Honor, I'd be glad to address that. First of all, the language in the email that Mr. Mowry received was that unfortunately we can no longer continue your assignee processing. No longer continue is the exact language that was used, that was communicated to him. Not we are, I mean, then it says, you know, because of that, you can, goes into the language saying, this does not represent a security clearance denial for a national security position. You are welcome to go ahead and say you were not denied a security clearance regarding this application. But the language specifically that was used in regard to and presented to at the time to Mr. Mowry was, we can no longer continue your assignee processing. And the determination, then it just says that determination was made during this process. And there's nothing, and specifically states there is no appeal regarding this decision. That's one of the factors that we identify in Egan, even though there was no, if we look to the letter of the law of Egan, even though there was no due process constitutional claim raised in Egan, it was not an issue. The Supreme Court spent a good amount of its analysis and a good amount of its time walking through the fact that there were other avenues available to that plaintiff, to Mr. Egan, to have his claims addressed. And for example, in fact, even this court's decision in Hagab made a point of clarifying that in that instance, the plaintiff had an opportunity where he was given the reasons for the adverse action and was given an opportunity to respond to them in detail in the administrative context. That did not happen here. Mr. Mowry was specifically told in the same email that there is no appeal regarding this decision, nor will any additional information be provided. And that has no basis in Egan, and that has no basis anywhere else in the law. I will also say that the language, to answer your question, Your Honor, as to the exact language of Egan, which was relied upon by now Justice Kavanaugh in the Foote decision, was where Egan states, predictive judgment of this kind must be made by those with the necessary expertise in protecting classified information. And that is the language on which now Justice Kavanaugh relied and went through the analysis that he did in the Foote case. I will also clarify that in Foote, it is true that that the circuit court's decision does not state the underlying facts and point to a specific fact made available. But if you go back to the district court decision in that case, it's in there. And in that case, the plaintiff alleged that he believed that the examiner, the apparently qualified, later determined to be qualified, examiner who did the psychological exam had determined that he had previously been disciplined in his employment with the Air Force, and that there were other reasons which are identified in the district court proceedings in that case. So it's not a mystery. It's not left open to be, just guessed at as it is here. That was identified.
I want to know this because I think it's important in terms of how I understand this case. I had alluded to the fact that maybe there could be this in-camera type review by a judge, but it does appear to me Egan does preclude that, or does it in your view? I mean, it looks like the majority precludes that in-camera review by a judge to go back and look and see, is there something other than religion that was the determinative of this decision?
Your Honor, I don't believe that it does preclude that review. Again, the language from Justice Sotomayor in the oral arguments in the Fazaga case, which the recent decision did not get into those merits. In that case, Justice Sotomayor said, I can't come up with anything where we've ever said that review by a judge in camera would be a risk to national security. So I don't think it's contrary.
But that's not the argument here. It's not about whether us looking at the documents would risk the information in the documents. It's about whether we should be reviewing this security clearance decision at all. Okay, that's a different argument.
And Your Honor, I believe Justice Gorsuch's comments during that same proceeding answered your question as to that, and what you had raised earlier, Justice Wynn, as well, when he stated that it is the court's role to preclude the government from using privilege as an offensive weapon.
This is not about privilege, is it? Is this about privilege? Have they asserted the privilege?
They've asserted that because of that Egan is meant to protect.
Have they asserted the privilege?
They have not asserted the state secrets privilege, which was at issue specifically in Fazaga. What I'm saying is that where Justice Gorsuch says that it's the court's role to preclude protection, I would say then, to paraphrase, or to what I believe that to mean, is that to preclude the government from using a protection such as the protective cloak of the predictive judgment here, I believe also would apply to that.
Are you asking us to
offensive weapon.
interpret? I'm sorry. Are you asking us to interpret statements by a single justice in a Supreme Court oral argument to overrule or interpret longstanding Supreme Court precedent and precedent of this court?
No, I don't believe that's necessary to do,
Okay.
Your Honor. And I think this is an indicator. This is a recent indication that we have from the justices of where they stand. I do think that the other cases, again, Webster v. Doe had a due process claim in it and alluded to, without absolutely recognizing that Webster v. Doe was not a Title VII case, but in Webster v. Doe, the Supreme Court referenced Title VII actions as being those where protective measures and the safeguards, as we discussed earlier, are utilized to properly balance this, the competing concerns or potentially competing concerns. We are not in any way, shape, or form saying that there should not be national security deference, given to the agencies who evaluate it. We are saying that the law does not mandate that it be simply a black box and you can't ask any further. The Supreme Court has not required that. This court has not required that. This court in Campbell applied Egan because it determined that the very same reasons that the plaintiff lost his clearance are the ones that led to the adverse action, which was before the court. And because it was those same reasons, this court decided that therefore it would be a violation of Egan. Egan applied and precluded evaluating what was behind those reasons, since the same reasons that led to the revocation of the security clearance in that case of Campbell v. McCarthy are the same ones that would have had to have been examined in the adverse action that took place as to the plaintiff there that was before the court. So I believe that that's appropriately brought. That is consistent with existing authority, is consistent with the prior holdings of this court as well as with the Supreme Court. And I will also just state briefly that in Becerra, again, there's a subsequent discovery of false information, which was referenced. And it's not always necessarily, highlighted and pointed to and with the spotlight on it in the circuit court case, but it's in there. And it is as with the Foot v. Monus, it's in the district court pleadings where they talk about the specifics that were identified and the specifics that Ronnie Foote, the plaintiff in that matter, was complaining about are that he believed that it was inappropriate to go back and look at the reasons that he had been disciplined as an employee for the Air Force. So with that, again, I will say that I believe that all of the language put here together that is before the court does not ask this court to make any ruling contrary to what this court's already made, and does not ask this court to make any ruling contrary to Supreme Court precedent. Simply requires that this court not further extend Egan to where instead of simply protecting a predictive judgment made by those with the knowledge and in the best qualified position to make that predictive judgment, don't extend it beyond the holding of Egan to say that appellees should be protected and shielded from giving any answer or any reason simply because they now say in litigation national security concerns were at issue, and we need to all just trust them on that. And with that, I thank you, Your Honor.
Thank you very much. Thank you very much, Ms. Jump. We appreciate counsel's presentations very much, and thank you. At this point in time, we would normally come down and greet counsel in the well of the court. We're not going to do that because of we're still under pandemic rules, but we'll thank you, and I'm going to invoke personal privilege and take a 5-minute break, if I may, and then we'll take up the final case of the day. Madam Clerk, thank you.
This honorable court will take a brief recess. the judges of the United States Court of Appeals for the Fourth Circuit.
Be seated. And our final case of the day is Goldman versus Brink and others. Mr. Ferguson, you're representing the board members of the election board or something like that?
That's right, Your Honor, yes.
And you're from the Attorney General's office?
Yes, sir, Solicitor General.
Good to have you with us.
Thank you, Your Honor.
And you may proceed.
Thank you, Your Honor. May it please the court, as Your Honor said, Andrew Ferguson representing the election officials. I'm joined at council table by Kevin Gallagher. The plaintiff in this case contends that Virginia broke the law when it failed to hold the 2021 election on the basis of census data, which did not exist when the electoral process began. We strongly disagree, but the question before the court today is whether it has Article III jurisdiction to decide this case at all. The answer to that question is no. To establish an injury in fact in a vote dilution case, the plaintiff must show an injury to his individual right to vote.
So you're arguing standing right off the bat.
We are, Your Honor.
And now the district court didn't address it.
Well, 2 points on that, Your Honor. We did raise standing.
Well, you had trouble understanding my question. It's a leading question. The district court didn't address standing.
He did address standing, Your Honor.
He did not address standing.
He did not decide standing.
He did not decide standing. All right.
That is right, Your Honor.
He addressed it. So he must have analyzed it.
He did, Your Honor. He did address it, but certainly did not decide it.
Okay.
To establish standing, he has to establish that the composition of the district in which he voted or would vote.
Let me tell you, in your notice of appeal, it relates to a sovereign immunity and order denying immunity.
That is right, Your Honor.
And that's the way you got into court here.
That is correct, Your Honor.
Okay.
So how do we get to standing?
I'm sorry, Your Honor.
How do we get to standing?
So because standing is
on sovereign immunity.
That's right, Your Honor.
Question altogether. The case is on. I mean, you may get there, but it's not without dispute as to whether we should address standing, whether or not that's something that's jurisdictional from the subject matter perspective. We can do it at any time, or you have to raise it, or it's interlocutory. I mean, it's a whole lot of questions there. And well, I appreciate you jumping right on to it, but there is that preliminary question. Do we address standing in this particular case?
Certainly, Your Honor. We think that it's both appropriate and necessary to address standing in this case, or if the court elected not to address standing, at least to remand. The reason that we think that it's...
Or we should not address standing and remand.
That is another option, Your Honor. We don't think that's...
Right, who would get it if we remanded?
So that is a good question, and the answer is I don't actually know.
You don't know?
That's right, Your Honor.
Well, there's only one case this comes up here from.
That is right, Your Honor.
It has a file number on it.
That's right, Your Honor.
We'd remand it.
We would remand it to the district court, no doubt. Who would comprise the district court on remand, I think, is a little bit unclear.
That wouldn't be up to us.
That's right, Your Honor. And it's not relevant, I think, to the remand question, except in this.
If we remanded, it would simply be remanded to the district court.
That's exactly right, Your Honor. And then
that'd be up to the district court.
That's right. And then there's potentially a dispute about whether they
could decide that among themselves.
That's right, Your Honor. No doubt about that. I don't think that directly affects the remand question here. Judge Winthrop,
are we required to address standing? Are we required?
Can reach the sovereign immunity question without first assuring itself that it has standing, because standing is an Article III prerequisite. And
to answer my question, you're telling me we are required to do.
I think that if the court elected not to, that the only appropriate recourse would be to remand. But if the court,
I mean, I understand that would be what we would do. I would think if you want to take it there, you could remand for termination of standing. But the question is, are we required to do that?
I do not think that the court would be required to do it unless it wanted to decide the sovereign immunity question, in which case I think it would first have to ensure itself that it had Article III jurisdiction.
So if we wanted to decide sovereign immunity, we have to address standing first.
I believe so, Your Honor, because it's an Article III prerequisite.
And, have you analyzed this in the context of Eichwander?
I don't think so, Your Honor.
You know what Eichwander stands for?
I know that it's a case, and I can't remember what it stands
for. It's an old Supreme Court case that established what they call the constitutional avoidance rule. That we ought not to take up constitutional questions or decide constitutional questions. Courts shouldn't. unless they have to.
That's right, Your Honor.
So sovereign immunity being a constitutional question, we shouldn't get to it unless we have to. And standing being a constitutional question, we shouldn't get to it unless we have to, but you're saying we have to reach standing.
Someone is going to
Or we have to send it back.
That's right, Your Honor. Someone will have to decide standing in this case. I don't think anyone disputes that, including my friend.
How come that one decided first down here?
Well, that is an interesting question, and it is not exactly clear to me. I did some investigation about why particular strategic decisions were made. I will put it this way. The Commonwealth did raise standing in response to Mr. Goldman's first amended complaint. Mr. Goldman then amended his complaint for a second time. When the Commonwealth moved to dismiss the second complaint, it moved only to dismiss on the sovereign immunity grounds.
So the Commonwealth didn't raise standing.
The Commonwealth did not.
So you represent here is the Commonwealth.
I represent the election officials who are sued in their official capacity.
When you say the Commonwealth, you're talking about yourself.
That's right, Your Honor.
The Commonwealth, so you didn't raise standing. The first thing you did when you stood up here today was raise standing.
So the Commonwealth did raise.
Didn't raise it in the district court.
I don't fully agree with that, Your Honor. The Commonwealth did not raise.
To get mad at over that.
The Commonwealth did not raise the arguments that it presses today with regard to standing, but did raise two standing arguments. One in response in the motion to dismiss the first amended complaint. The second at the request of the district judge who wanted standing briefing. Judge Novak then in the hearing on October 12th raised a standing theory very similar to the one that we pressed today, but Your Honor is correct. We did not raise the particular standing arguments that we raised today. Again, I don't think standing is not forfeitable or waivable, so we can be addressed at any time and has to be addressed before.
It's jurisdictional.
That's right, Your Honor.
And it's constitutional.
That's right, Your Honor. And so insofar as the Ashwander principle would apply, I with respect, I don't think it applies here because this is a constitutional statutory or constitutional jurisdictional prerequisite. There's no way to avoid this one. This will have to be decided.
You bring to us sovereign immunity question, and you say ultimately standing will have to be grasped. The best that I can see you did below was to say it was a problem, but there's not a lot of articulation on it below. The question is why can't decide the sovereign immunity question and it doesn't get rid of standing? When you go back, you can bring that up.
So that's true, Your Honor. We of course could bring this up at any time. I think that the reason that sovereign immunity shouldn't be addressed before determining standing is that if the court were to issue an opinion on sovereign immunity, but subsequently determined there had never been any standing in this case, that sovereign immunity opinion is effectively an advisory opinion because the court never had jurisdiction to issue it in the first place. So I think that's why the order of operations.
It would be until it's determined you didn't have standing.
Well, that in a sense, that's true, Your Honor. But
a valid opinion, a judgment is valid until there is a determination that there's something that made it. Well, to say without jurisdiction.
To some extent, that's true, Your Honor. But if, for example, this court were to deny the sovereign immunity defense and we appealed that decision to the Supreme Court and the Supreme Court determined that there was no standing, it would vacate the lower court judgment because it would have lacked standing from the get-go. So I don't mean to suggest that what the court would say about sovereign immunity would be invalid, but I think it would be slightly jumping the gun if it issued a judgment with regard to sovereign immunity without having assured itself of its Article III jurisdiction.
The lower court did exactly that.
I agree, Your Honor. And I think that Judge Novak was correct that the posture in which that case finally got to the end was a little bit unusual. I point out as well that at the hearing where he issued the order that we are appealing here today, he set up a schedule to very promptly decide the standing question. But whether that schedule would ever become effective was contingent on.
And you disrupted the schedule by filing your notice of appeal.
So that is true, Your Honor, but his schedule was.
So you took it away from him. He said he didn't have any jurisdiction after you filed your notice of appeal.
Well, it's true that he didn't have jurisdiction.
Well, he did. He doesn't have jurisdiction in a general sense, but he has jurisdiction to act in aid of the appeal after you file a notice of appeal, and you didn't tell him that.
But that's right, Your Honor. He also stayed proceedings below pending.
He stayed the proceedings.
That's right, Your Honor.
But he could have acted in aid of the appeal. And it seems to me that ruling on the standing question in the first instance would have acted in aid of the appeal, and it would have expedited these proceedings. To the extent there's any time constraints imposed in these proceedings, you all have delayed it by the way you conducted this appeal.
But respectfully, Your Honor, I don't think that we've delayed it. We had a statutory.
You filed the notice of appeal and didn't permit the judge to rule on standing, even though he had asked for briefs on standing, I think, or said he was going to.
He had established a schedule to.
That was the schedule.
That's right, but it was contingent on us not filing the notice of appeal.
And you filed the notice of appeal, and then the briefs were never filed.
That is the
delayed the case.
Well, the notice of appeal did in fact stop the case because Judge
You're only
Novak.
appealing the sovereign immunity, which you come up here and tell us now you can't decide that unless you decide the standing first.
Well, I do think independently of the way that this was conducted in the district court, every court has to assure itself of its Article 3 jurisdiction, even if Judge Novak had decided.
Question really goes to piecemeal type ways of litigating. You don't just bring us something up on sovereign immunity, then something you didn't even bring below come up and says, oh, we don't have standing. We got it. Yeah, you got it here now. You're saying you ought to now adjust this before you get to sovereign immunity. Judge King is saying, why didn't you just wait and do it where you're supposed to down in the court, then bring us the case? Because now we got a situation, I don't know where we're going standing or we're going on sovereign immunity. Both are jurisdictional to some extent. I mean, so we got this competing situation here. We don't like to take cases piecemeal. That's all that means. You forcefully argued, I think, going a good way. You ought to know if you got jurisdiction to do it. Well, you ought to let the trial court do its job first.
So I understood, Judge Wynn. With respect, the Commonwealth had 30 days to notice its appeal of the interlocutory.
And it took 7 days.
Well, because Judge Novak said he wanted an answer in 5. That's right. He wanted an answer by October 18th, which we gave him. But if, Your Honor, we had filed our notice of appeal and Judge Novak did, as he could have, left the standing issue and let it resolve itself while the appeal was pending, it still would have proceeded piecemeal because the sovereign immunity question would be before this court while the standing question was still being adjudicated below. And in any event, even if Judge Novak—
You didn't have to file your notice of appeal immediately. You could have permitted the judge, at least under your definition, 3 more weeks to decide the standing issue.
Well, Judge Novak—
You had 30 days and you filed it after 6 days.
The statute gives us 30 days, but Judge Novak said, I want to know by October 18th whether you're—
He gave you 6 days to file a notice of appeal.
That's right, Your Honor.
So you said, so he amended the 30-day rule.
Well, I don't think he amended the 30-day rule, but he did say the rest of the case and the rest of the order is contingent on the Commonwealth filing a notice of appeal within 6 days of the order.
When was that 3-judge court appointed?
On the exact same day that the order under review was issued, October 12th. It noticed to the docket on October 13th, but the order from Chief Judge Gregory was dated October 12th.
So there's a 3-judge court, 3-judge district court that's handling this case.
There's a 3-judge district court has been convened. No action has had to be taken because of the stay.
It's the court. Those 3 judges, Judge Thacker of this court, one of the members, is presiding over the case.
That's right, Your Honor.
So if we were to remand it for standing, I would go to that 3-judge court.
It would, Your Honor. There would then be a preliminary question about whether Judge Novak is required by 2284 to decide the standing question first, because it's a threshold question that runs to the substantiality of the federal claim. And a 3-judge district court is not supposed to entertain federal claims under 2284 that are insubstantial. And a claim lacking jurisdiction is per se insubstantial. This court has said that since the 1950s. But yes, if there were a remand order in this case, it would go to the 3-judge court, and then there would have to be litigation over whether the 3-judge court decides it in the first instance.
We do have a number of sister circuits who looked at this collateral order doctrine. And some of them, looks like to me, they've said that we shouldn't consider jurisdictional issues like standing when you have a collateral order. Has this circuit rejected that view?
It did, Your Honor. In a 2003 case, it held that a plaintiff had standing on an interlocutory order and noted that it had to consider standing because the absence of standing would be a jurisdictional defect. I want to point out further that just as a matter of first principles, I think it would be a little bit anomalous to say that the Steel Company command doesn't reach interlocutory orders, because then the courts would effectively be free to issue advisory opinions either under a collateral order review or interlocutory review. And I don't think that the jurisdictional command of Article 3 kind of stops at the door of an interlocutory review. Now, I concede in this case, there's a separate question about whether remand is the appropriate course to decide the Article 3 question, but I don't think there's any meaningful dispute about this court's authority to decide it. And insofar as it wants to reach the question presented by the collateral order.
So it's a discretionary call on our part?
I think that the question of whether to remand or to decide it in the first instance is a discretionary call. Now, I think that the better exercise of discretion here is to decide it now, and I think that for 3 reasons. The first is there isn't a
normally, though, you agree as we're a court of review and not a court of first view. We look at what somebody else did.
That's right, Your
another
Honor.
judge did, what the district judges did.
That's right, Your Honor. And I think that there are 3 good reasons for the courts to decide it in the first instance in this case. The first is there are no factual disputes about the jurisdictional question.
What if they want to do discovery? You can have discovery on jurisdiction.
That's right. There can be jurisdictional discovery, but I don't think there are any meaningful factual disputes at this point, Your Honor. The only question is the appropriate framework by which to judge the standing analysis. So at this point, it's a legal question that this court can decide in the first instance. Second, I think judicial economy.
Can I ask you on that? What about candidate standing? There's I think an argument that you make about whether he's ready and able or whatever the standards are, and the courts who have looked at those factors have looked at deposition testimony, evidence. They've looked for evidence that the candidate is ready and able, but we don't have any of that because we haven't had any jurisdictional discovery yet.
That's right, Judge Rushing. I have 2 responses to that. The first is the allegation in his complaint, which is the only thing he could get discovery to prove, is that he was considering running for an election. Even if the Commonwealth were to stipulate that he is considering running for election, just as a matter of law under Carney against Adams, that is insufficient to establish standing, even if he could prove that he was considering running. And I think the second point is—
You're saying that discovery would be circumscribed?
Not circumscribed. I just don't think it's necessary at this point because the dispute is purely a legal one.
He could do, the judge could allow him to do discovery, and the judge could allow him to amend the complaint if he wanted to.
Well, so when my friend on the other side—
While they're trying to figure out this jurisdictional question.
When my friend on the other side amended his complaint for a second time, Judge Novak told him there would be no further amendments of the complaint given how many he had already had. Of course, the district court could change its mind on that, but at least as this case arrives now, we've reached the end of the complaint amendment process. My second response on the candidate standing problem, Your Honor, is that we're in this slightly strange posture where the election, the constitutionality of which he is challenging, is fully in the past, and that his candidate standing argument now appears to be, I have standing to challenge an election that took place in the past because in the hypothetical future, if a district court exercised its equitable discretion to impose a special election, I am considering standing in that special election. I think at this point, that's just as a matter of law far too attenuated on which to base a candidate standing argument. And I've gone over my time. Unless the court has additional questions, I'll reserve the remainder for rebuttal.
Wait there a moment.
Sure.
Judge Rushing, you got anything?
Thank you, Your Honor.
Thanks very much, Mr. Ferguson. We'll get back to you here in a few minutes. Mr. Goldman?
I'm going to have to sit. I heard if that's so.
That's fine, Mr. Goldman. You go right ahead.
I don't really know where to start.
Starting with the question of whether this matter we are required to address standing.
Okay, let me just go over some points that he made in terms of the candidate standing. What I said was what any candidate would say. You'd want to at least know the district you were in and the voters you were appealing to before you could make a decision.
My question is—
I can't hear you.
My question is, are we required to even address standing in the posture of this case this time?
No.
Or is it something that we should send back for a limited remand or some type of remand for the trial court or whatever, the tribunal to address?
Well, as you know, I don't even think they filed it correctly. Let's go through how this occurred. Judge Novak issued his opinion and then requested a 3-judge court from Chief Justice Gregory. In order for Novak to ask for 3-judge court under the law, he has to decide that there's a substantial federal question. They could have challenged his request for a 3-judge court.
I don't want to overstate this, but what I'm more interested in is what this court should do right now. What we should do. This matter is before us, and the question that was brought to us is one of sovereign immunity. Generally, in sovereign immunity under the collateral order doctrine, we do not address other issues like jurisdiction, including standing. Of course, your counsel on the other side said there are cases in the Fourth Circuit that says we should. May well be. My question to you is just that. Are we required to address standing? And if not, then should we send it back without getting into the 11-minute business of sovereign immunity and have the court determine that, whichever.
Yes, Your Honor, I addressed that in my brief, and I said that it was inappropriate to raise standing in an interlocutory appeal, and this should be sent back, but it has to be sent back to the 3-judge court. They want to send it back to the district court. That doesn't exist anymore. The 3-judge court, once it's appointed, has now assumed the role of running this case. And in fact, they filed their notice of appeal. And if you look at the top of it, it's in the general appendix. It says it went to, the 3-judge court. It was all logged in. The 3-judge court has taken over this case. And he says it has to be decided. Judge Novak asked for a 3-judge court. They could have objected to it. They didn't. They now have the case. It should be remanded back and let them have it, and they can discuss standing. Number 2, Judge Novak specifically in his order said, I am reserving the standing question to me, and he can reserve the standing question.
Why does it make a difference which forum we send it back to? If we send it back, why would it make a difference as to whether Judge Novak does it or the 3-judge panel? I understand you say he no longer is on the case. That may well be the determination. It may be the determination by either he or the 3-judge panel. But why should we get into that question at this level? If we make the determination, it's something that should be addressed. We need to send it back. Somebody needs to address it. We don't need to make that determination. And I doubt it's going to be error regardless of who objects as to the particular forum, unless it's a jurisdictional error. But so you seem to make it as though that's a contention between you and the government as to which forum it gets sent to. And I didn't hear that from the government. The government is very forceful in saying we ought to address it, first of all. But if you do, just send it back. And the question is would that be a problem of just sending it back?
In my opinion, which is all I can give, based on the McManus case and based on the fact that a 3-judge court has been convened by the chief judge of this court, and under the rules, as I read the cases, they now have the case. They are the only ones you can send it back to.
That doesn't make a difference to us.
Well, again,
if we send the case back, we send it back to the district court, period. And that they deal with it. But it seems to me like you all pretty much agree on what needs to be done here. You're saying it should be remanded. They say for standing, they say we should address standing, but they don't care if it's sent back for standing. Why couldn't you come up with a consent order and tell us that you want to make a joint motion to remand for consideration of the standing issue or consideration of whatever?
I can't say, but perhaps
I don't know what we're going through an exercise here. I'm not sure we even need.
Excuse me, Your Honor.
And let me tell you, I've sat on those 3-judge panels. That statute also says that a single judge can act to conduct proceedings except for the trial. So a single judge actually could potentially do this.
That's correct.
And so the question, if we send it back, and ultimately, we may just be going around in circles on this, but don't you agree that sooner or later standing is going to have to be addressed?
Yeah, absolutely. And I was prepared to do it.
And if standing is addressed adverse to you, is there any need to talk about sovereign immunity?
No, and in fact,
there wouldn't be. So that's almost like, even though they're both equal jurisdictional rules, but one is certainly precludes the other, big time.
Yes.
If you don't have standing, no need to talk about sovereign immunity because you're not going to get there. So the question is, I understand that the council gave the unusual posture with the 30 days and the judge giving you just 6 days for the notice. I don't quite understand that, but nonetheless, I'll accept that. But at the end of the day, there ought to be a way we can say, go back and fix this and address standing.
Yes, Your Honor.
And you can, we could get up and argue about, is there standing for voter participation? Is standing for all that back and forth? Sounds like fact finding to me to some degree, and we don't like doing it. No, we don't do it. If we can help it, I can tell you that.
Well, I think that if we look at the case at the hearing, Judge Novak said, well, why didn't you challenge your standing? He asked them a question. And they said was, well, we think we can do sovereign immunity and that'll take care of it. The fact of the matter is, this case has taken 9 months, and when they did Cosner, it took 2 weeks. This has been a delay case, and this is why this is the way it is. Judge Novak, in fact, I was working on a stipulation of facts when they decided to file their notice of appeal. We were working on a stipulation
And
of
they didn't have a
facts.
choice. Said you had 6 days or so.
I'm telling you, I was working on it, and then they called me. I remember I said, well, why should I have to draft the first draft of it? It's your appeal. Well, you're the plaintiff and you have to do standing. Okay. It doesn't bother me. The facts are way more. And I do have standing, by the way, and I can't wait to get into a courtroom and show why I have standing, because this whole case is to try to get people their right to vote. It took 2 weeks, 40 years ago, and it's 9 months now. And I'd be happy to do
Maybe you ought to
standing.
go ahead and make your case as the way you have standing, because you never know. My colleagues and I, we may say we do need to address standing.
Well,
So maybe you
they don't
better
have
talk
to.
about why you think you have standing.
I don't have, well, if it's going to be remanded, why would I?
No one said
If you're
that.
asking
No
me to
one-
do
I'm
that,
saying
sir?
That is a potential situation. You're here in this court now.
Yes, sir.
I wouldn't talk about a remand. I'd talk about what you are facing right now. Anything can happen in this court at this point. And one of the things you want to be clear about, you say you have standing, you need to tell us why you have standing.
The reason I have standing is this. The standing question, in terms of candidate standing, I said what any candidate would do. I gave you the Favors ver Cuomo case. Nobody, and I've run campaigns, nobody's going to say definitively they're going to run for something. They're going to consider it unless you know, number one, the district you got to run in, and therefore you want to know whether you can win. You're going to run as a Democrat or Republican. That is what you do.
Can I ask you about that?
Uh-huh.
I didn't see any representation that the districts were changing. This is about, you've raised, your only federal claim is about malapportioned, right? There's voter dilution. So how does alleged dilution of the vote in your district injure you as a candidate in that district?
Well, because I'm going to be running in a future election. The question is, was I going to run in a future election, not whether I was going to run in the election that was already taking place.
Yeah, let's assume that you are going to run and there's sufficient evidence that you are going to run. How are you injured by voter dilution in your district if you're a candidate?
I am asking in here for an election in 2022. They say there won't be an election in 2022. I want to run in 2022. The state says they're not going to hold an election in 2022. I say Cosner says I have a right to run in 2022. They says it doesn't.
Cosner you're talking about a district court case from 40 years ago?
3-judge court case. Was decided,
A district court case 40 years ago.
but decided
That's
favorably.
That's your authority for saying there's going to be an election in 2022.
Well, under the McManus case, it says that if you rely on either
No,
opinion.
that's not precedent for the Fourth Circuit. That's a district court decision of 40 years ago
Well,
and a different set of facts.
well, that's true. It may be a different set of facts, but the fact is, it
District
is.
courts don't make precedent for us.
You need something else other than that case, is what Judge King is saying to you. First of all, it's not even precedent. And then it's 40 years ago about an election coming up. So that's not going to work.
Well, what I am discussing is the fact that I am challenging that the elections in 2021 were unconstitutional. We have to have a new election as soon as possible to fix it. I believe it's 2022. I want to run in
So you're
2022.
saying the nature of the relief you seek gives you standing?
Well, if I
You're
am,
saying you want an election this year, 2022. I can't keep up with the year.
in order to
But
get,
you're saying that since you won an election this year, that gives you standing to sue.
the standing to sue comes from the fact that they had an illegal election that diluted my vote in 2021. I want the remedy to be an election in 2022. That's the remedy that I want.
2021, it's over with and been certified.
Excuse me?
The election in 2021 is over with and been certified, and you say it's an illegal election. That's
No, I
another
said they
basis
ran-
for your
yes.
standing.
They used
Illegal
unconstitutional
Conducted
districts.
in 2021, and the fact that you won an election in want to have us to order an election in 2022 or district.
The districts in 2021 are unconstitutional. The variances was 80%. The state constitution says they were supposed to do it. They didn't do it. They argue that's a state claim. Cosner said it wasn't a state claim. If Cosner's not there are two other. You have the case of Bush v. Gore, and you have the case of Meyer v. Grant, which says that if a state gives you a right to vote, that even if they didn't have to say we must have an election in 2021 under the new districts. But if they do, those cases say that your rights protected by the 14th Amendment if they take it away. Well, they took it away. They didn't hold an election under the new districts. They held an election under the old districts. Number two, they didn't seek a court order to violate the state constitution. The state constitution of Virginia is unique in this country. It's the only one that says in 2021, which is the year after the census, you shall have the election under the new districts. The only one that's in there. Bush v. Gore and Meyer v. Grant, in my opinion, stand for the proposition that if they grant you that, you're protected by the Equal Protection Clause. That's a federal claim. Third, Reynolds v. Sims says that if you don't do decennial redistricting within 10 years, it's constitutionally suspect. Their plan right now is not to hold an election under the new districts until 2023. That is 12 years. That's constitutionally suspect. That's another federal claim. No state in the history of this country, Virginia or America, has ever waited to 2024, 2 or 3 years after the census, to seat a constitutionally approved General Assembly. Virginia will not elect the Senate under the new districts to 2023. Now, for the first time in history, they're not going to elect it to 2023, the House district. That means they won't get seated to 2024. That raises under Sims serious constitutional questions. That's the basis of my federal claims. I also think I have a claim as a candidate because they're denying me an election that I think I'm entitled to. And in the case of, I cited in my brief, it's Roger Gregory wrote the opinion. It's Mallory versus, I forget the name, Harrington or something. He cites Cosner favorably and says, as Cosner says, that citizens have the right to have a vote for a constitutionally approved, a sound legislature as soon as possible. That's what I'm asking for, as soon as possible. They denied me in 2021. I don't want to wait till 2024 before it seats. That is the basis of my claim, and that is standing to me. And if we want to get into they're not challenging that the scheme they used in 2021, an 80% variance between the least populated and the most populated district. Harris v. Arizona says you can't have more than a 10% variance.
I believe they're saying that's not the way you measure it, right? You want to talk about that they say you're supposed to measure against the ideal district.
Yeah, can I address that? Because they completely misstate Brown v. Thompson. Completely. And if you look at Harris v. Arizona, I think it's 1306. Harris v. Arizona says exactly what, and they cite Thompson. What they said in their brief was this: Mr. Goldman, yes, your district is 6.5 over, using the 210, okay? But it has to be at least 10% over for you to have standing. That is not what Harris stands for. That is not what Brown says. You measure the variance between the least populated and the most populated. That's the first question you have to answer. When you have something that's more than 10%, okay? If it's less than 10%, you probably can't sue. You're not going to win because that's within the range they allow it. If the variance is more than 10%, then it becomes constitutionally suspect, and the state can overcome that, but they have to present evidence, which of course they don't want to do. They never want to go to an evidentiary hearing. That is what Harris says. So the ideal district is a mathematical tool that is used to do the over and under. It's a mathematical tool to determine what the maximum variance is. Read Cosner, read Harris, read Brown, every case, that is how you determine what it is. Mahan v. Howell said the maximum variance was 16%. It's now down to 10. That's roughly where they are. This is 80%, so they can't defend it. And I'm saying that because my
Is that
district,
just the rule in gerrymandering and redistricting cases, or is that the rule in one
Reynolds
person,
case.
one
No.
vote, voter dilution
in
cases?
the Reynolds case, they misunderstand how you do gerrymandering. They misunderstand Gil. Reynolds says, I'm entitled to an equally weighted vote compared to everybody. Everybody. They say because my district is only 85,000 and the ideal district is less, that I can't suffer any harm. That's not what it says. The smallest district in the state, 67,404. Mine is 85,223 or 85,344, depending upon which number you use. That's more than a 20% variance.
So that's the fundamental question of where you are dealing with redressability. You say you look at the least populous, compare it to your district, and then you do it. I don't know what site you go with on that, because what Judge Rushing is going is that it seems that the size of your district would be based on the one person, one vote principle, which you would do by looking at the representation that you're going to get in light of the new maps. So if you revise this map and look at how you actually going to be voting, it looks like, I don't know if there's a reduction or increase in your recommendation on it. So, I mean, that's not the same comparison. It's not what actually happened between those two. It's if you did, once it's revised, then there's a comparison of the one vote, one person type of principle. One person, one vote principle.
Excuse me. I still think you used the 2010, but Reynolds says I'm entitled to an equally weighted vote. My district's 85,000 or whatever it is. There's another district of 67.
There's no disagreement on that. The disagreement comes is, how do you determine what's equally weighted?
Because
you are looking at what happened, the actual votes from the old ones based to and the districts, how they configure it, as opposed to the way what's ultimately going to happen. In other words, how your vote is going to stack up with these counties and then the other districts in light of the redistricted vote.
But that dilution occurred when the vote occurred. Most of these cases, you challenge a scheme that hasn't been put into effect. And this is the unusual circumstance where I was diluted in 2021. I was supposed to have a new constitutional districts. They didn't give them to me. And I showed you the huge variance. That's when my vote was diluted. It can't be fixed.
That's where we're having some difficulty understanding. It looks to me that, yeah, you're right if you look at the old one in terms of rep, but in terms of the maps and how the district happens, you in fact look like you're going to be overrepresented by where you are now, as opposed when these maps actually come out.
Not in the legislature, sir. The legislature is based, the reapportion based on the election, based on the using the districts in that's the problem. I got to wait till 2024 before my new district kicks in. I am still represented by the people picked in the old districts, and that's the harm. That's why you can't do it. That's the unusual circumstance in this case. Normally, when you challenge your redistricting after they pass it, and they're going to use it in the future, you say, hey, the new districts they have, then you show the variances. Here, they've already diluted me, and I can't fix it till 2024. It's never happened before. That is my harm. I can't fix it unless they give me a new district as soon as possible. That's what Cosner was saying. That's what Chief Judge Gregory was saying, and that's what Reynolds says. It doesn't matter whether I'm near the ideal district or not. It's that this legislature is based on a scheme for the next couple of years where my 85,000 people get the same representative as somebody with 67,000. And there's not a case that says that is legit, because it can't be. It violates the very basic premise of Reynolds, which says I'm entitled to it equally. And that, now, once, yes, and we have the new districts. And if we had a district and if you had an election under the new districts, it wouldn't really matter whether it was ideal or not, because if it was constitutional, it would be 10%. Some people would be lower than the ideal, some people would be more. But my vote is being based on a 2010 census, districts drawn to a 2010 census, and for the next 2 years, I'm being diluted, as is every other, if you look at my exhibit, there are 20, 30, 40 districts that suffer from that. There's one district's got 130,000 people in it, and there's another district with 67,000. They propose that doesn't change to 2024. It is blatantly unconstitutional. And I'm in this courtroom today to try to get justice, not just for myself, but as Earl Warren said when they were doing the Reynolds v. Sims, that I'm actually here for those others similarly situated. They're looking at the wrong thing. I was diluted in November 2021, and they're saying, well, you know, we've passed new districts and it's mathematical. It doesn't really go into effect at 2024, but you're cool now. No, I'm not cool till I get my constitutional right to have equal representation in the legislature with my vote, and that won't happen until there's an election under the new districts, and that's what Reynolds stands for.
Mr. Goldman, I believe we understand your position, and we appreciate your spelling it out.
Thank you, sir.
And Mr. Ferguson, you've reserved a few minutes.
Thank you, Your Honor. I just want to make 3 very quick points. First, Judge Wynn, in response to your question about case law in which the court could consider standing in an interlocutory review of an order on immunity, the 2 sites from this court that I provide for you are Williams against Hansen, 326 F. 3rd, F. 569, and District of Columbia against Trump, 930 F. 3rd, 209, although that one was vacated on for other reasons subsequently to that. Second, my friend on the other side, I think, seems to suggest that the Commonwealth is afraid of the merits argument on this case about whether the 2021 election was constitutional. I just would like to be very clear. We are not afraid of the merits. If the courts conclude that Mr. Goldman has standing to maintain his claim, we will vigorously defend the constitutionality of the 2021 election. We do not think the 14th Amendment requires states to reapportion on the basis of census data that don't exist when the electoral process has begun. And third, Judge King, I think there was some suggestion that both sides were okay with the remand. I would just like to be very clear. We strongly prefer that the court decide standing in this instance, and I think that it's appropriate for 3 very quick reasons. The first is
but you say we have to decide standing first and foremost, and you want us to do it.
That's right, Your Honor.
And in the alternative, you want a remand.
That's right, Your Honor. That's exactly correct.
We can't address the immunity question unless the standing question is resolved in favor of Mr. Goldman.
That's right, Judge King. And the reason that we think it's appropriate for this court to do it, and then I will sit down, are the following 3 reasons. First, the dispute at this point is purely legal. I know that there's a dispute about whether the 2010 or the 2020 census should provide the ideal district.
But there's a pending motion here before us to augment the record. Even now, there's a pending motion filed by Mr. Goldman to put additional things in the record, which we haven't ruled on.
That is correct, Your Honor.
So there are the parties, only one of them at this point, is trying to augment the record on appeal at this stage.
I believe that the motion was to augment.
You want us to act as the trial court and the appellate court.
With respect, Your Honor, I'm not asking this court to act as the trial court. Most of the things in the proposed supplemental appendix are just documents from the lower court litigation. So this isn't a meaningful attempt to expand the record. So I think this is, in fact, purely a legal dispute. Second, insofar as this is a purely legal dispute, and we believe it is, I think judicial economy weighs pretty strongly in favor of the court deciding it now. We don't think this is a particularly thorny standing question.
Time constraints that you know of?
Well, so I want to address that question third. And I think that the answer is no for the following reason. The relief that my friend on the other side is requesting has obviously posed some systemic concerns about what the electoral process this year will look like. Again, our position is that the 2021 election was perfectly constitutional and no remedy for any constitutional violation was required. But obviously my friend disagrees and insists that he's entitled to an election now. We think that the court quickly resolving the standing dispute insofar as the court believes he lacks standing will help alleviate that systemic uncertainty. I think that's consistent with the Supreme Court's Purcell against Gonzalez principle, which says that courts are supposed to stay out of election disputes once we're close to an election. In just the last couple of weeks, the court has repeatedly said we're already so close to the 2022 election that federal courts should be staying their hand and not issuing injunctions with regard to state election rules. So insofar as this is a purely legal dispute, we believe it is, and insofar as it would favor judicial economy, we think it does. I think that the additional benefit of the court resolving standing right now would be that it will alleviate potential systemic uncertainty about what the 2022 election cycle will look like. And with that, Your Honor, we would ask that the court vacate the lower court judgment, remand with instructions to dismiss the complaint. Thank you all.
Thank you, Mr. Ferguson. We appreciate the oral arguments by both sides very much, and if we could do so, we'd come down and congratulate the parties and counsel, and thank you for your services personally, as this court has a long tradition of doing. But we're not doing that because of the pandemic. We'll hope to do that the next time you're here. And with that, Madam Clerk, we'll adjourn court until 9:30 tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.